Today is October the 14th, 2021, and I'm Jose Smith, the special magistrate that will be hearing cases today in the city of North Miami. The special magistrate is empowered under the laws of the state of Florida and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by the code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so therefore all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have interpreters who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witnesses that you may have should announce your presence. When asked, please speak directly and loudly into the microphone and say your name, spell it, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney or affidavit in order for your testimony to be accepted and admissible on behalf of the property owner. For new cases, you will be asked for the record if you are aware and understand the violation that is being heard today. And do you understand what it is that is required to resolve the violation? Please answer accordingly. The city will present its case first, and then the property owner violator will be given an opportunity to testify on their own behalf. You can bring witnesses to testify, present any evidence and photographs, and also you will have the right to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city code exists or existed at the property, then depending on the case type, I will set an abatement date for the violation to be resolved, or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement case by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or continue this case to another hearing date in the future. If you do not agree with my findings of fact and or my ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim transcript of the proceeding. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the responsibility of the appellant. And it is recommended that persons who plan to appeal their case should provide their own court reporter at these proceedings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, this city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. Madam Clerk, is it your opportunity now to continue, or should we do the Pledge of Allegiance?
The clerk, if she could go ahead and read through her instructions for the hearing magistrate, and then we'll do the pledge and then the swearing.
Very well. Please proceed.
Good morning, and thank you for participating in today's special magistrate hearing. I will review the process by which today's hearings will be conducted. Make sure your device is muted at all times unless you are giving testimony on a case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive a notification giving you access to audio and video so that you may give your testimony. If you are physically in the code compliance department and wish to give testimony, you must sign in with the code clerk and await the text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the clerk to be provided access to the computer. If you would like to speak on behalf of a case, once the case is called, you should click the raised hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during the case, please include that when your case is called. And your magistrate, that concludes the instructions.
Okay, thank you very much. Is the officer prepared to give the Pledge of Allegiance?
Yes.
Just a moment while I raise the flag.
They can hear you.
Find my flag here.
Oh, no, they should hear you. No, hold on. She's looking for the flag. There it is. Okay, you can begin.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. So she's going to begin with the oath.
Code officers, can you please enable your cameras, please?
It's going to enable the code officer's cameras.
Can you, officer, if you don't mind, because Pilar, you have all you're connected, so that means we can't hear her. Can she lower her mask or you pull out your headset so she can be heard?
Okay.
Or you, yeah.
She's just saying.
Now, if you are giving testimony today on a case, please rise and raise your right hand as I issue the oath. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Yes.
Thank you. Can we get the interpreters, please, to enable their cameras? Code officers, please disable yours. Shanna, please disable your camera. Okay. Can we do the interpreter?
The interpreters, okay.
Can you give her
Are
your...
they ready? Okay.
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
Thank you. Thank you.
Pilar?
Your magistrate, there are no amendments or deletions to the agenda, so I will begin with case number 15 on the agenda, First Florida Bank. Give me one moment, please.
Are the parties here?
Yes. The case number is FYBRR 2020-00092. The property address is 12500 Biscayne Boulevard. Gary Beswick is the officer.
Okay. Who's here on behalf of the property owner?
They're going to turn on his camera in a moment.
Hello, my name is Mario Polo.
Yes,
Mark, can you swear him in, please?
good morning.
Sir, can you please raise your right hand for me? Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Sir, spell your last name for me.
Polo.
And what is your relationship to the property?
I am the area director for Boston Market.
The area director for Boston Market.
Correct.
What does Boston Market have to do with First Florida Bank?
I don't know. I was just told here to come. I was given the citation. And we have hold on a second. I'm not sure if First Bank owns the Boston Market location. I don't know. Again, when I got here this morning, I noticed that the code or the case number didn't match up to a Boston Market name.
Gary, is this the right case?
Yes, that's right, Kate.
Yeah, let me hear from the city.
Good morning, Gary Beswick from the city of North Miami. The Boston Market is the tenant of the location. The 40-year recertification actually goes to the property owner, but they're the one that occupy the space. So that's why they're here.
Well, I don't know that the tenant has the obligation to follow the 40-year recertification. This is a responsibility of the owner. I don't quite get why the owner is not here.
Well, the property owner was notified, so.
The owner is not notified.
No, the owners was notified, but I've been talking to the representative from Boston Market over the last, I guess, week or two. But they're the one that's in the space. So basically, they need to communicate with the property owner, but regardless, the building do need to be recertified.
Okay. Is this a one-tenant building?
Yes.
Mr. Polo, does Boston Market have a long-term lease on the property?
Yes, and we have repairs in process. We have a vendor, ASG Engineering, who will be out at the property on Friday to begin the work and to.
Yeah, I haven't gotten there yet. Let me just.
I can barely hear you. I'm sorry.
Yeah, let me just understand where all the parties are. This is a commercial property on Biscayne Boulevard. Boston Market is a long-term tenant. Correct. And the owner of the property, not Boston Market, the owner of the property who has been notified, has a responsibility under the city code and the county code to comply with a 40-year recertification required. And Mr. Beswick has indicated the owner has been notified. The owner is not here, but obviously Boston Market has a very significant relationship or a very significant property interest here. So is the city trying to cite the tenant?
Well, no. Basically, I'm not sure what kind of lease agreement Boston Market have with the property owner, but based on what the gentleman just stated, they hire an engineer service that going to do the inspection. So basically, all we seek in adjudication with abatement date as it's past due.
Okay. All right. What is the status of the property in terms of compliance with the requirements of the code?
At this point, we don't know because this passed due from last year, so we haven't got a report of the property, so that's why it's here now. We haven't gotten an initial report as yet.
All right, I'm gonna make a statement because we have a lot of cases on the agenda this time dealing with the 40-year recertification, and in the wake of what has happened with Surfside and Champlain, we're gonna start asking more questions and being a lot more careful about granting extensions, especially when the work or the problems that need to be resolved involve life safety issues.
I agree.
Okay, so we're going to be extra careful. So I will be asking not in all of these cases, how long have they been out of compliance? Has a report from an engineer or an architect been submitted? Have issues been identified? Have those issues been pending for a while? And what has the property owner done to repair the defects and deficiencies, if any, were found by the report? And finally, are there any life safety issues that we need to address? So all of these questions, I'm going to be asking them. So be ready, Mr. Beswick, because I'm not going to grant any extensions unless I'm confident that that the work that needs to be done can be done relatively safely in a short period of time. In this particular case, I'm familiar with the building. It's a one-tenant building. And you're telling me that there are no life safety issues and that an extension, a brief extension, is acceptable. Is that?
That's not what I'm telling you. What I'm telling you is...
Tell me what you tell me what you want me to know.
Okay, what I want you to know is this is a new case. The report was due from 2020. We haven't received no report as of today. So basically, based on the gentleman's statement, they're in the first stage of hiring an engineer company that's scheduled to be on the property on Friday. So at this point, we need an adjudication with an abatement date.
Okay, I know that Boston Market will do the right thing for its customers and the city and the residents. So I will agree to an adjudication with an abatement date. And so my ruling then is that on the basis of the testimony of the city's code compliance officer and the evidence presented depicting that the violation for failing to comply with a 40-year recertification requirement, that violation is still in effect. Proper notice has been given to the owner. The long-term tenant is present. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Do you understand, Mr. Polo, what my ruling requires?
Correct. Yes, I do.
Okay, so you got 60 days to get that recertification done, and that requires either an engineer or an architect to certify that the building is safe from a structural perspective and electrical perspective. If
parking lot illumination.
I'm sorry?
And parking lot illumination as well.
Okay, whatever is required, you need to do that within the next 60 days. Otherwise, fines of $500 a day will start accruing. So with that said, thank you very much. Let's hear the next case.
Thank you.
The next case is item number 10, Caridad Properties 1 LLC, case number FYBRR 2020-00002. The property address is 12500 Northeast 4th Avenue. This is a new case. The officer is Gary Beswick.
Give me that case number again, on the agenda.
Item number 10, Caridad Properties.
Okay, I got it. Who's here on behalf of the property owner?
He's getting settled in, magistrate, if you just give him a second. He's getting settled in, magistrate. Oh, whoa, that was weird. It was an echo.
Hello, everyone.
Good morning. Can you please raise your right hand, sir, so I can give you the oath? Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Take your full name again, sir, for the record, and your property address.
Yes, my name is George Darter, on behalf of Caridad Property LLC, and the address is 12500 Northeast 4th Avenue.
Spell your last name.
D as in David, A-R, D as in David, E-R.
Okay. And what is your relationship to the property again?
I'm the owner.
Okay. Do you understand the nature of the violation?
I understand why I'm here today. Yes, sir.
Okay, and it's a 40-year recertification requirement.
Correct, sir.
Where are you in the process?
Well, I am right now dealing with Mr. Gary Beswick. This is a situation that's been going on. It's a little confusing because of the property folio. I can explain if you allow me just a second to lead
Briefly,
to
sir,
it.
briefly.
Yes, briefly. It's a two-unit it's a two-building properties that share the same folio. I received this information from Mr. Beswick about a year ago, and I sent a letter letting them know that the building is vacant and going through a CRA process. The building, there's a second building that is being used, which is where I live. It's a two-unit building. And again, when I started this, I sent in, it's a little confusing because they were talking about Caridad Property 12500. There's a second address, which is 373 Northeast 125th Street, which is where I live. So I was complying to the 2500. A month ago, I went directly to meet Mr. Gary Beswick at permitting to let him know I'm really confused because I got a letter from him saying that the time was approaching for, to get this resolved. I explained to him the situation. It was still a little bit confusing, and he finally realized, yes, there is a second property that needs to at least get its 40-year certificate, which is where I live. And I thought that was fine. That was three and a half, 4 weeks ago. I ran to do this. I got the inspector to come over. They found I just have to repair plaster cracks onto the building and then get the 40-year. That now, when I started doing that, I had to stop the whole process because you need to get, in order to do that, you have to get a contractor. I went and researched and realized that I could do this on my own with an affidavit, which I have here. So I've been in the process of doing 1, 2, 3 the way that it's supposed to. I work with the city. I appreciate Gary Beswick. I appreciate what everyone does. I just want to get this done properly. And so that's why I'm here. This is the first time I show up to one of these court hearings.
All right. Let me ask you a couple of questions. I'll let Mr. Beswick testify in a minute. How old are these buildings?
They were built in 1926. I restored them from slum to a very nice building. And I mean, the one that I'm living in. The other one is, the facade is beautiful, but still it has to be redone. I'm dealing with Durham right now with fire and for that building.
All right. Just answer the question. So 1926, they're both 1926 buildings.
Yes, sir.
Okay, and they're both they're not single family resident. They're not residential properties, are they?
Yes.
Well, yes, they are. Yes, thank you, Gary.
Okay.
It's a 2-unit and then a large house.
Okay. And you understand that under the law that you cannot serve as the person to certify the property. Maybe you can do some work on your own, but you still need to hire an engineer or an architect.
I did. I called them in. That's what I mean. They're the ones. I did the inspection as Gary asked me to, and then they said I just have to repair the cracks, do the stucco, and that's where I'm at. So okay. I mean, I've been doing it. I'm doing.
Can I give us some clarification?
Yeah, one second, Mr. Beswick, please.
Oh,
1 second. How much time do you need, sir, to do whatever you need to do?
Well, it could be done quite quickly. The thing is now, as I said, I researched to see if I could go ahead and be the contractor for this through the affidavit, because again, I own the building. I live in that building. I actually live in that structure, and I have the permit for the insurance, and I took it to the permitting here in North Miami. And I'm a little confused with this whole process because they say I can't, but I read it and it doesn't say anywhere where you can't. I have it here, and maybe you could clarify this. It's just a paragraph, sir, and maybe you could tell me if this is possible or not.
All right, let me hear from Mr. Beswick.
Surely, of course.
Okay. The answer to your question is no. You cannot do it as a property owner. Not 2 reasons. It's a commercial property, and the property is under LLC. They need a licensed general contractor.
There you go.
Oh, but that doesn't say that here. That's why I understand Gary Beswick, but I read this over and then it doesn't say this. This is why I like to share this.
What are you referring to? What are you reading from?
It's an owner building affidavit disclosure statement form where I take responsibility for doing jobs under 75,000. I mean, there is a paragraph here, and again, I'm reading it, and I respect his proof, but I go back and I read this, and I don't see where it says that applying to me. So that's why I'm a little confused.
You know, the Florida Building Code is hundreds and hundreds of pages, and it requires a little bit more than just one page to summarize what it means. There are certain things that an owner builder can do, and there are certain things that an owner builder cannot do. And that goes to whether it's $10,000 or $75,000, you can't do electrical work because you're not an electrician. You have to understand that certain trades require licensing, and just because you're an owner doesn't mean you can do it.
No, I'm not doing it. I'm hiring the licensed, I'm hiring the people that do have the license to do it with the insurance. This is about becoming your own contractor, not doing the work.
Mr. Beswick, can he be his own contractor and farm it out to an electrician?
No, it's a commercial property and it's under LLC.
All right.
Yes. Mr. Darter.
Yes, Mr. Darter.
Yes.
I am bound by the technical and legal interpretations of the building official. I cannot overrule the building official when it comes to interpreting the code. The code, according to what I'm hearing, if you can't be a general contractor on a commercial property, perhaps, other people may feel differently, but I have to accept that. So you need to comply, and I'm going to give you some time to go ahead and do whatever you need to do. And so how much time do you need?
Well, in order to not have a heart attack and a nervous breakdown, I think 2 months to 3 would be fine, only because I'll get it done quite quickly, because that's where I'm at. But I like to know that I have that time frame. And Mr. Beswick has been incredible. He has not been at any point not coherent, carrying with the situation. I just, as a resident, want to always see what my options are. But yes, this started 3 weeks ago, and I think I've gone pretty fast in order to get this moving. But I would like some time, yes, just to know that.
Mr. Beswick, since these buildings are 1926 buildings, this is not a 40-year recertification.
Well, I'm not sure. I don't remember if it was built 26, but it's possible this probably be like is 10-year interval, because it's 40 year, then 10 years intervals. So this might be the 10-year interval.
Yeah. So he should have done a 40-year recertification maybe 20 years ago. But since we are where we are, this is why we need to start cracking down on buildings that have not complied. So, Mr. Beswick, are you okay with 90 days or?
Yes.
You are?
Yes.
Okay. All right. So, we're gonna enter an adjudication, sir. And, Mr. Beswick has been very, very lenient with you. I would have given you less time because of the fact that, since 1926, this building essentially has not had any recertification. Should have had one many years ago. I haven't known it that long. Okay, so but somebody should have done this 20 years ago, and so here we are. Yes. So based on the testimony of the city's code compliance officer and the evidence presented depicting that the cited violation exists, proper notice has been given to the owner. I find in favor of the city. Enter an adjudication and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. So get it done quickly, okay? And hire a competent general contractor.
We're there. Just quickly, this is about the 373 address, correct? Because the other building is under CRA and that is vacant. We're talking about this one building, right, Gary Beswick? We're
We're talking about the building that was, that you was notified. I don't have the file in front of me, so whichever one you was notified.
Well, that's the problem here. I was notified at 12500 Northeast 4th. That's the building that's vacant. The one that recently was told that if you're living in that one, this is the one I need the 40-year for, which is 373 Northeast 125th Street. That's why I'm really here to try to clarify this so I don't get penalized for something that is just a misunderstanding, in the records because of the folio.
Okay, hold on. Crystal, could you pull out the file for me? Okay, according to the file, it's building number 2. So whichever building is building number 2.
Correct.
That's the one that is building number 2.
Which would be correct. There you go. Thank you for clarifying that to everyone. All right.
Well,
That would
let's not just leave here thinking that only building number 2 needs to comply. Every building in the city needs to comply with a 40-year recertification. So the fact that you were not cited on the other property where you currently reside doesn't mean that building is exempt.
We understand that building, the reason why that building is, we have a $250,000 project going in there. And if it starts now, then we don't get reimbursed. So it's vacant and it's waiting for approval, which should be in the next month or so, but that's going to take about a year to build. It's going to go into construction. It's renovating old building into its wonderful glory, like this building that I live in now.
Yes, sir.
Yeah,
So,
well,
let me interject a minute. Okay, let me interject a minute. Okay, the property of 2 buildings.
Right.
Only 1 building is due for recertification, which is building number 2. So that's all the building you need to focus on for now. When the building number 1 is due, you get a notification for building number 1. But the one that is due is building number 2. So that's the one you need to focus on.
All right, so that's clarified. All right.
Thank you.
Thank you very much. Have a nice
Be
day.
well. Thank you. You also, everyone. Thank you.
All right, where do we go now?
The next 2 cases is item 36 and 37 for Raro Investment Trust. Case number CEFLR 2021-00029 and CEZCU 2021-00064. Both cases are for property 12191 Northwest 7th Avenue. They're new cases, and Shanna Sanders is the officer on both cases.
Are we going to hear them together?
Yes, Magistrate.
Okay. All right, let's hear the business tax receipt.
Just a moment, Magistrate. We're just trying to get the party situated at a computer. Clerk, can you administer the oath?
Can you please raise your right hand? Do you solemnly swear and affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
Yes.
Thank you.
Take your name, please.
Max J. Roberts.
Max, last name?
Roberts.
Roberts. Okay. What's your address?
12191 Northwest 7th Avenue.
Okay. What's your relationship to that property?
I'm one of the trustee of the trust.
Okay. So Raro Investment Trust is a trust.
Quite.
Okay. It's registered with the state of Florida as a trust?
Quite.
Okay. Who's the other trustee?
The wife, Nanin Jodone.
Okay. All right. You've been cited for failing to have a business tax receipt for expert signs and printing. You understand that?
Yeah, I understand that. And the problem was we were debating about the corporate. It was a corporation. We were in the phase of changing the corporation to an LLC. But as of right now, it is inactive in Sundays. So we do have, the NAC Corporation LLC that's going to replace that. We're still waiting for State of Florida to have it online on their website so we can go ahead and do the process. But we already have the EIN from the Treasury Department, and we already have a doc number for the new LLC. So that should be resolved pretty soon as we're able to get it online.
Okay, so you're telling me that the trust is inactive and
not the trust, the expert sign, because the trust don't have anything to do with that. We get cited because we're the owner of the building, and the business is expert sign. That's the business that gets cited for the.
Okay. So regardless of the owner, you're doing you have a business. The business is owned by somebody.
Yes.
Who's the owner right now?
The building, the business owned by us too. So the building it's owned by us, and the building it's owned by us. Okay.
So whichever entity is owning owns the property needs to have a business tax receipt and a certificate of use. How much time do you need to comply?
We're in the process of doing that for the trust, which we already submitted the application. We're waiting for the approval. For the expert sign, that corporation doesn't exist anymore. We're in the process of waiting for the state to have it online before we apply for the tax receipt and the CU. So as soon as we get that on the Sunbiz website, we'll be able to come to the city. As you know, Florida is one of the hardest states right now for corporation. It might take a while. We're waiting to see if they're gonna have it, but we do have a documentation number and the EIN from the Treasury Department. So
you're in the process of forming a corporation. That corporation will eventually own the trademark, the business. So that corporation is going to have to apply for the business tax receipt and the certificate of use. Okay, that's all the city is asking you to do.
Yeah.
Is whatever corporation you're going to end up forming. And by the way, you can form a corporation in 15 minutes. Whether it's registered on our website, that may take a while. Whether you get, your tax ID number, whatever it takes, that may take a while. But as far as registering a corporation, you can do that online in 15 minutes. So,
it's already done, sir. We're just waiting for the state to have it online. So
you don't need to wait. You don't need to wait for that. You can go to the city. You can apply for the business tax receipt and the certificate of use, and you're done. Okay. It doesn't take more. It doesn't take more than a day to get all this done. So I'm going to give you a week to get to get your act together, because this is very simple stuff. You don't need to overcomplicate it. Okay. So based on that, I haven't heard from the city. Does the city agree that a week is sufficient to comply, Ms. Sanders?
What up, Mr. Sanders? City of North Miami Co-Compliance. Yes, I agree. A short abatement is good. He's aware of what's going on, so I'm in agreement with that.
Okay. This is not, rocket science. So based on the testimony of the city's compliance officer, the testimony of the property owner, the record, I find that the violations exist for both, for business tax receipt and for the certificate of use. I find in favor of the city, enter an adjudication and set a compliance date of 7 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So let's do it. Okay, let's not put it off anymore.
Yes, correct.
All right, next case.
The next two cases are item 28 and 29 from Marjorie E. Tapia and Elizabeth. Case number MHBIO 2019-00447. This case was previously adjudicated with an abatement date of February the 4th. The fine set as $300. The property address is 525 Northwest 134th Street. The second case is RCCOR 2019-00050. This case was previously adjudicated with an abatement date of February the 4th. The fine set was $300. Both cases are for Officer Gary Beswick.
Okay, I see that I previously adjudicated both of these cases, provided an abatement date and set a fine. This is for permits for interior and exterior alterations and a reoccupancy certificate. Here we are several months later, and the cases are back before me. So absent some very, very exceptional reasons, I'm going to ratify these fines. So want to hear from the property owner before I make my decision.
Ma'am, can you please raise your right hand so I can swear you in? Do you solemnly swear and affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you
Yes.
God? Thank you.
Your name, please.
Agindra Lopez.
Okay, Ms. Lopez,
Yes.
what's the problem?
The problem is the garage was converted. We went back to Miami-Dade County, but they decided because the way of the flood elevation is too low, it doesn't qualify to be converted into a bathroom and bath. So it had to be demolished and go back and put it as an storage without the bathroom. So we had to change the scope of work. She bought the property assist from the previous owner who did the violation. And we tried to comply, but comply something that is going to pass inspection, and not comply with something that is not going to pass inspection.
Well, how long ago did you buy this property?
The property was, I'm the, 10 months. I'm the permitting company. I'm trying to help the owner, and she's not here today because her father is at the hospital. She always be here at all the hearings.
What is the relationship that you have to the owner? What is the property?
We have a company who do permits for them, and we work with the engineer, he was there on the last hearing, park engineer. And she was the one who hired an engineer before contact us. And the engineer, his name is Fermin Martinez. He passed away because of COVID, and she lost all the money. So she started all over again with the new engineer.
So you're the permit runner?
Correct.
The expediter?
Correct.
And
what happened is, we've been telling her, because she bought it as a bedroom and bath, and she valued the appraisal as a bedroom and bath, but we told her it's not going to pass inspection. It's not. So we decided to demolish and convert this. Yes.
Ma'am, you have no nexus to the property. By that I mean, you cannot speak on behalf of the owner. You don't have an affidavit on behalf of the owner. The owner has not, sent an authorized agent. Do you have any contracts with the owner to do what you're doing right now?
Yes, we have it. And we've been all hearing. God knows that every hearing we've been here because we're helping a lot of homeowners in North Miami who have reoccupancy problems.
Well, I've been very lenient on this property, and what we were expecting was that by now, whatever mistake was made when the property was purchased with a garage converted into habitable space, I would have thought that, back when I heard the case, which must have been last year, that by now, a year later, something would have been done.
It's done. When we went the first time to a hearing, she didn't have no plan. We did have the plans corrected back from the Dade County to North Miami, and in basically in the stage for their review again as an storage and get it approved. That's it.
Mr. Beswick, let me hear from the code officer. Mr. Beswick.
Okay. There's some confusion going on because the last time when the engineer was on a hearing, he claimed that they're going to turn the room into a storage room, but he never mentioned anything about the bathroom that was added. So the issue is because they don't want to go to Durham to pay that impact fee. But in order to keep that bathroom, it got to go through them. So if they're going to turn it exclusively into a storage room, they got to demolish the bathroom as well.
Okay, this is part of the scope of work. The bathroom is going to be demolished, but the problem is not because paying the impact fee. You're wrong about that.
That's
It's
what he
because
said.
the flood of the property, it doesn't allow to be into a living space. It doesn't have it, and she cannot raise the ceiling. So
No,
it's something
we
they
know
cannot
we
do
know
that.
that we know that, but she can't have a bathroom either.
She's not going to have a bathroom. The new scope of work is demolition of the bathroom and keep this place as an storage. That's it. It's not going to be used as a room. That's it.
So how come it hasn't been done for a year?
It's because she bought the property as a value of bedroom and bath, and she was thinking that she could keep that because it lowered the value of the property. If you have one bathroom less, we tried, but it's not going anywhere. It's not working. So we decided plan B, storage. That's it. Finished. No bathroom, nothing, just an storage.
All right.
That's her first house.
I'm very disappointed that a year later we're still talking about a bathroom. Okay, and I think that I've bent over backwards to accommodate the property owner, but there comes a time when you do or die. You either comply or you face the consequences. There has to be consequences when you've waited a year to do the right thing. So I'm going to ratify the fines, and then you deal with the city to if you can show good faith or good reason, you can talk to the city and have the fines eliminated. But I'm at the point right now where I'm going to ratify the fines. So based on the testimony of the city's code compliance officer and all of the evidence that I have considered previously, I find that the property has been out of compliance since the abatement date of February 4th, 2021. I ratify the fines accrued to date in whatever that amount is, 300 per day, and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. So I'm done with this case. Now the fines.
So that means that she doesn't have to come back again to the hearing. The fines are going to cover every day, right?
The fines are going to be accruing every day, and the city is obviously authorized to put a lien on the property, and ultimately, if necessary, foreclose on the property. But we've been very patient, and I think it's.
No, I understand.
These proceedings.
But basically, in order to
please don't speak over me. I'm in the process of making a final statement.
Okay.
You should know, since you're in the business, that there has to be an end, and we just can't continue over months and months and months of non-compliance. The city has an interest in ensuring that people comply with the law. Okay, and if the property owner made a mistake, if she was misled, let her go to court and let her sue the prior owner. But the city needs to come to closure on these kind of cases. So with that said, ma'am, that's it. I don't want to hear any more. Okay,
perfect. Thank you, sir.
Have a nice day.
Thank you.
Next case.
The next case on the agenda is item 23, Keystone Point 2020 LLC, case number CEBPR 2021-00046. This is a new case for property 12920 Aurelia Road. Jose Perez is the officer.
Excuse me, Pilar, the young lady who just spoke, she also has another case, which is my case.
I don't understand.
We read both cases into record, 28 and 29, Vanessa?
Yes, she's here on behalf of Rockwood Investments as well, which is the 865 Northeast 138.
Okay, so I'll call that one into record.
Okay.
So just for clarity, Magistrate, I apologize, one of the officers interrupted to identify that the lady that's here is here on behalf of another item on the agenda. So while she's here, if it's okay, we'll just hear those cases as well.
Yeah, let's proceed with the whatever other case she has in front of us.
So that item is 44 Rockwood Investments Incorporated, which is a new case with the case number CEBPR 2021-00059. The property address is 865 Northeast 138th Street, and Vanessa Willis is the officer.
All right, let me hear from the officer first. Let's see if we can narrow that issue.
Good morning.
Okay.
Good morning, and I do apologize for the interruption. This property, 865 Northeast 138th Street, was cited back on August 11, 2021. Please obtain all required building permits for renovations on or in the home. I observed new windows, doors, and a garage door that had been installed. And upon a reoccupancy inspection yesterday, it was determined that the kitchen and the bathroom had been renovated as well, and there were no permits in the file. The violation was sent certified mail on August 11, 2021, and was delivered on August 16, 2021 at 10:41 a.m. And as of September 16th, I posted the notice to appear, the affidavit of services in the file. Also on 10/4, October 4th, no permit was recorded for windows or doors. There were no permits other than the roof that was installed on.
All right, why don't you show me some pictures of reflecting the work that was done without a permit? Okay. All right, you showed me a truck full of debris. What else?
That was the before, while they were doing the work. That's that picture there, and the windows had already been installed. The roof is finished on that photo.
Okay, do you know what kind of windows those are?
I'm not sure if they're impact resistant or not. They appear to be, but I'm not positive on it.
Okay, so what else? Windows,
doors, garage door, and then we found out yesterday that the interior had also been renovated. The kitchen and bathrooms have also been renovated.
Okay, was it Miss Lopez?
Yes,
Okay, you represent the owner, correct?
correct,
And that's Rockwood Investments.
correct.
What say you about?
I went yesterday with Gary to do the reoccupancy inspection because what I told them, they didn't work without permit. And I told them, I want to go with Gary first, pay the expedite for the reoccupancy because they didn't do the reoccupancy anyway. And he specified what scope of work has been done without permit. That way, when we submit the plans to the city, we don't back and forth with this problem without, they say, oh, we changed this, but we changed this. Like, for example, the garage door, when we went yesterday with Gary, he determined the garage door was not changed. The garage door is existing and it's from the previous, it was only paint. But the doors, the windows are an impact window. They replaced the kitchen cabinet, and in one bathroom of the property, they did replace the top and the vanity.
Was this done by a licensed contractor?
Yes. We don't know. We are the permanent company. We're thinking yes, because when she saw the truck full of debris, they did a roof without permit. That's the only they did it with permit. The roof. That's it.
Is that correct, Ms. Willis?
That is correct. The only permit on file is for the roof.
Okay, but there's a question about the garage door, whether that was done or not done, but clearly there was some other work that was done without a permit, correct?
Correct. Remember, when I'm doing the inspection, I only have access to the exterior. Mr. Beswick obtained access to the interior yesterday.
Mr. Beswick, are those impact windows?
I didn't check if they're impact windows or not, but they're 100% are brand new windows, and the kitchen was completely renovated, and the bathroom was renovated, not just changing what she stated. It's a renovation.
Ms. Lopez, do you understand, or does the owner understand what needs to be done in order to legalize the work?
Yes, that's the reason that we went with Gary yesterday. So it's because we have a problem in North Miami. A lot of owners tell us that they did change too, but they don't know. When Gary goes to reoccupancy, they have pictures from before and after, and he find out more stuff than what really it is. So that's why right now we have clear picture of the older stuff that's been done on the property.
Do they have a contractor right now to do the work?
Yes.
Do you have an architect to draw plans so that the city can approve them and get the work done? If those
Yes.
windows are not compliant, they're gonna have to be replaced. You understand that?
The windows are an impact window, and the plumbing company went yesterday and passed the camera through the whole system to make sure that they didn't change any like on the ground on the property. It was only in the plumbing.
No underground plumbing work.
No, we had the video from the camera. That we
Okay,
did
how
yesterday.
much time do you think the owner will need to legalize the premises and bring the property up to compliance?
Whatever time the city decide to give it to them. But we're
Right.
thinking because it's not a need. The problem is when you have to go to the county over there is the timeline of the problem because the people are in Beswick. But in this case, it's not new addition. It's a work existing. So it's only in Miami.
Miss Willis, how much time are you willing to give her?
30 days.
30 days?
30 days is not enough. All the architect is full of work with the drawings.
Yeah, I think she's gonna, unless you're telling me that is there anybody living there?
No, the property is vacant.
It's vacant. So I think I can be a little bit more lenient knowing what the process is like and needing an architect and a licensed contractor and getting workers to do things and then getting the building department involved. So I'm going to give them 60 days. And if you come back in 60 days and you show me good faith and you show me that you're moving the project along expeditiously, I may be a little bit more lenient than I was.
We need to do right away because it's a lot of people try to break in. I know Miami Police Department already went to the property twice, so we're gonna have.
Okay, stop. Don't again. You seem to want to interrupt every time somebody wants to say something. Okay, you have to stop. Okay, listen to me. Quit while you're ahead. I'm willing to give you more time, and I'm telling you that if you move along quickly and get the work done expeditiously in good faith, that comes 60 days, if you convince me that you're acting in good faith, I may give you a little bit more time. But right now, I'm going to give you 60 days. So based on the unrebutted testimony of the city's code compliance officer and the building official's representative and the photographs and evidence I've seen depicting that the violations are still in effect, they still exist. Proper notice has been given. The owner's representative has testified. I find in favor of the city, enter an adjudication and set an abatement date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Thank you, ma'am. You may leave now. Have a good day.
I have one more case.
You have one more? Well, if the city wants to call out that case, we'll hear it now.
Okay.
What is the name? What is the name on your case?
That one is
Who's the officer? All the officers are here. Who has the case for her?
okay. This is for Keystone Point 2020 LLC.
Okay, that's Keystone Point 2020 LLC, case number CEBPR 2021-00046, property address 12920 Aurelia Road. Jose Perez is the officer.
What's the number, Pilar?
23.
I thought we just heard that case.
We were gonna hear it and Vanessa called hers. Okay.
Ms. Lopez, are you here also on Keystone Point
Yes.
2020 LLC?
Yes.
Okay. You're an authorized representative of the owner?
Yes, and he's also my family.
So you're here, you're telling me under oath that you're representing the owner of this property?
That's correct.
Okay. Do you need some after the fact permits for a wooden deck? Do you contest the violation?
No, I am not.
Okay, so how much time do you need to, let me hear from the officer first. Obviously, you don't have to be a genius to see that there was a wooden deck put in front of the house. I want to hear from the city on this one.
Officer Perez of the City of North Miami. This is in regards to the property at 12920 Aurelia Road. This is in regards to a wooden deck that was installed in front of the property. Unfortunately, it was done without permits. A stop work order was placed on the property. However, work has continued since then. At this point in time, as of my reinspection date, no permits were issued for the wooden deck. And the city is seeking an adjudication with a compliance date.
Is there more work than just the wooden deck? Is there work inside also being done?
So they appear to be remodeling the entire property. In this specific property, there's two separate cases that were opened for construction without work. Construction without permits. This wooden deck is in the front, and then there's work being done in the rear of the property that was observed at a later date for the seawall and or dock in the rear that's being also renovated without permits. So, but that's a separate case that hasn't been set for court yet.
Okay. I'm not going to ask you how much time to give them because I know what your answer is going to be. It's up to me.
Yes, sir.
So, Ms. Lopez,
Yes.
when can you get this dock, not the dock, the deck? When can you get the deck legalized? Or how much time do you need to do that?
They can give me 60 days.
What?
60 days.
Okay. I'll give you 60. But don't come back and ask me for more because you're the one that said 60, okay? So based on the testimony of the city's code compliance officer, which is unrebutted, the photograph clearly depicting a dock in front of the house done without permits, and that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Ms. Lopez, in the future, I'm going to require you to have an affidavit from from whoever you represent that you've been hired as an agent, and that your testimony given under oath binds the property owner on any statements, commitments, admissions that you make here. To the extent that you may, be able to the extent that you may provide additional services, you have to let the city know. You're not a contractor, you're not an architect, so I don't want to get into an issue where you are practicing architecture or contracting or even legal work without a license. So, you're so far everything is cool, but if you go outside of what you do for a living and you start giving opinions on construction and on legal matters, you may get into deep waters. Okay.
Okay.
Thank you. Have a good day.
Thank you, sir. Have a good day.
Okay.
The next two cases are going to be for Arcade Plaza, item 39 and item 40. The first case is CEFLR 2021-00037, property 12105 Biscayne Boulevard. This is a new case. And the second case is going to be CEZCU 2021-00068, 12105 Biscayne Boulevard. Shanna Sanders is the officer on both cases.
Okay, who's here on behalf of the business? Hey.
Laura, what are we?
This is the case where Pedron and Isaiah Valcena are going to testify on.
Sorry, but can you tell me who's here? Like, what?
I don't see any customers. Oh, Andrew Zidar and Russ Lobello.
Well, if they're present, please speak up.
Hi, good morning.
Okay, Andrew.
Good morning.
Okay,
Russ, if you can enable your camera, please, so that we can swear the two of you in.
I'm trying to figure out how to do that.
I sent you a link to do so.
There we go.
All right, I see Mr. Lobello. Anybody else? Is there an Andrew? I thought I saw a name.
I'm here, yes.
There he is.
Good morning,
Andrew,
Your Honor.
how do you pronounce your last name? Zidar?
Zadar.
Zidar, okay. All
Can you
right, go ahead.
Can you please raise your right hand? Do you solemnly swear and affirm that the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
All right, this case is against RK Causeway Plaza LLC. Based on prior experience, the tenant has appeared before me on issues involving certificates of use and 40-year recertification and conditional uses and so on. Who do you represent? Who are you? Are you the tenants? Are you representing the owner?
I'm with RK Centers, the ownership group. I think Russ is one of our tenants there. Denny's. Russ, I think maybe you just got a copy and you're here because something was maybe delivered to the business. Is that true, Russ?
It is, and I'm actually the one that has to get the licenses. So that's why I'm appearing, because I have the detailed information about where we stand with all of that.
Okay. So the two cases I think were in front of you, Your Honor. One is a 40-year as it relates to me, I believe, and one is it just Russ's licensing? Is that correct?
That I'm aware of, yes.
Okay, there are 3 RK cases on the agenda. Actually, there's more than that. There's like 5. So, Ms. Zadar, Mr. Zadar, you're on the 40-year recertification. So let me.
Yeah.
Okay, so let me just hear from you first, and then we'll deal with the business. The 40-year recertification is the more serious issue. This all pertains to the building at 12101 Biscayne Boulevard, correct?
That's correct. So yeah, and obviously I was here for the first 2 cases and understanding, the city's concern and where we are in the world given what's going on. So we've already completed the report, electrical and structural. They've both been submitted to the city. We received, I believe, 2 comments. One was because it's one folio, there's a few different buildings. The building official or somebody in the building department asked us to have the reports done separately, one for each structure, even though they're one folio. So we've asked the structural engineer to do that. And the comment on the electrical portion was the parking lot illumination, which when we started, I did not realize was part of the process, but we've asked the electrical engineer to complete that. The reports submitted show no life safety issues or anything pressing that would be a concern for the public safety. So we're working on getting the paperwork and the illumination stuff done.
How old is the building?
That's a good question. If I'm ballparking, I'm guessing we're in the 90s. We've owned it since 2002, 2003, somewhere around there. But I don't think it's too much older than that. If I had to tell you, guess.
All right. If it's in the 90s, then the 40-year hasn't run yet, so it's probably
certainly late 80s. I mean, unfortunately, late 80s is for early 80s. I'm sorry.
Yeah. Let me hear from Gary Beswick on the 40-year recertification.
Good morning. I'm Gary Beswick from the city of North Miami. As it stated, the report did submitted, and as he also stated, the report needed to be separated for each building, and also each of them was open as a separate violation. So what they did initially was they came in with one report for everything with one fee, so it was kicked back. So basically, we're waiting for them to bring it back. We haven't got it back yet. So we need one report for each building by itself with a separate fee by itself. So each of them is standalone, even though it's one folio, it's per building. So each building we need a separate report.
Okay, that's more of technical bureaucratic issue. I'm more concerned about life safety issues. I know that the report identified some issues. I think I read part of it. What is the biggest issue right now with the building or the buildings? Is it an electrical issue, structural issue? What's the problem?
I don't have the report in front of me.
I can pull it up, but we don't have any issues. Like I said, on the structural portion, it was more paperwork, bureaucratic, like you mentioned, and the electrical was, we were only missing the illumination report. But both properties, or all the properties under both reports, were deemed safe for occupancy by the inspector, and no issues.
All right.
We're only with the parking lot lighting.
He told me he hopes to have it done for me for the end of the week. With everything going on, these guys are busy right now. So I've told him I had a hearing and that I need to get this done. So I was able to give you guys an update today, and
okay.
he was hoping to have something for me before the end of the week.
Okay.
And I explained the urgency to him, and given the case issue.
So Sessions Magistrate, as what we're seeking is adjudication with a abatement date.
Okay, as to all buildings.
Yes.
It's one folio, but there are several buildings, and they need.
Yes, I remember somewhere the thing is 3 separate violations or 2 separate. The violations open separately per building. Okay,
so I think you could probably get it done within 30 days. Is that true?
That seems reasonable. Yeah, that seems reasonable.
Okay, so based on the testimony of the city's code compliance officer and the evidence presented, noting the owner's issue with the electrician and that representations that it can be done within 30 days, I find in favor of the city, enter adjudication, set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. If you run into a problem and you're acting in good faith, I know these reports take forever, and sometimes the engineer is busy doing other things. But if you're moving in the right direction and you need more than 30 days, you can come back. But right now, you got 30 days. Okay. Thank you.
Sounds good, Your Honor.
Okay.
Can I ask the code officers, are the next 4 items for us, are they all licensing issues related to tenants?
Well, I'd ask Andrew that you stick around because these are your tenants and these issues, they involve you. Yeah.
No problem. I'll be here. I'm gonna go on mute.
Yeah, you can go on mute, but I want all owners, not just this particular owner, but I want all owners to understand that these violations that are issued for BTRs, for certificates of use, and so on and so forth, ultimately it's the owner's responsibility. I know that the owner has a lease agreement and that the tenant is responsible for these types of violations, but ultimately the city will go to the owner to ensure compliance. If the tenant runs away or doesn't comply, the city is looking at the owner for compliance. So, Mr. Lobello, we like to hear from you. What kind of business do you operate? Where is the business? And do you have any issue that you want me to hear? Any problems with the licensing, and how soon can you comply with the requirements?
Your Honors, I operate a Denny's 24-hour restaurant at 12105 Biscayne Boulevard, and I am the franchisee. And we applied back in July for Durham for Miami-Dade County because it's a part of. I have to have their blessing or their certification on the application prior to sending into North Miami. I have a tracking number and a process number that we did apply in July. We have not heard yet back from them on that. I have an expediter who is working with them to expedite the permit, or not expedite the permit, but expedite the process. The process number is MU Mary Up 21006383, And as early as last week on Monday, the expediter was in their office. They told us that by the end of the month, they would have their comments to us. Then we would have to correct, if there are any corrections, then we would make those corrections. Once that's done, we have everything else that is needed and necessary to then go into the North Miami city to get the licenses. But sir, I have no control over Miami-Dade County, Durham, and we're pushing as hard as we can to get this to give us their certification.
Okay, I'm going to let the officer speak. I'm a little bit confused as to why Durham is involved in the first place. This is a business tax receipt issue. It's basically a tax on a business, and then a certificate of use, meaning basically that your business is in compliance with zoning. Why is Durham involved? And you know, let me hear from the officer as to what the problem here is.
Shanna Sanders, City of North Miami, Co-Compliance Officer, City of North Miami. I've been honest enough to say I can't answer your question as to why Durham is involved. That's why I've asked our zoning clerk, Isaiah Valsane, to log on to the meeting so that he can give testimony from our conversations with myself as long with the franchisee. He's had contact with the city way back from May, if not June, about things that are going on with the property. You know, as we are here today, violations still exist. So, you know, if I can, I'll let Isaiah state why Durham is involved and why it's taking so long.
So, Magistrate, we have someone from the zoning office who could better speak to your question.
Okay, before I go to the zoning folks, do you need a certificate of use in order to apply and receive a business tax receipt, a BTR?
Yes,
yes. They go together?
Yes, it goes hand in hand, but you start first with the certificate of use before the business tax receipt is issued.
Okay, and the certificate of use is basically a zoning issue, right?
Zoning issues the certificate of use.
Okay, so what zoning issues are there?
It's a process, Your Honor.
Okay, go ahead.
There's a process, and yes, you do have to go to Durham. It's a restaurant, so you do have to go to Durham.
You have to go to Durham for what reason?
Probably the grease trap. It's a restaurant.
Yeah, but can't you apply for and receive a certificate of use and a business tax receipt in the city of North Miami while still waiting on the Durham issue?
No.
No?
Can we let the zoning office address your questions, Magistrate?
Yes, of course.
Isaiah, can you unmute yourself, please, so that you can answer the questions in relationship to the CU?
Hello, good morning. Can everyone hear me?
Yes, if you wouldn't mind arranging your camera so we can actually...
Yeah, we can only see half of your face. Okay, perfect.
Okay, so based on a couple of meetings that we've had, that the zoning office has had with...
Has he been sworn, by the way?
No, yeah. Can you please state your name, what your position, Isaiah, and clerk, can you please swear him in?
My name is Isaiah Valson, and my position is a zoning clerk.
Please raise your right hand, Isaiah. Do you solemnly swear and affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Okay, so based on a couple of meetings that we've had in the past with Durham, all businesses would need to get their approval. According to them, there has been a couple of, in the past, we've had a lot of businesses, we've issued licenses to businesses who don't have Durham approval, and that's been a major issue. So what they've done now is started this, pretty much enforce the Durham approval process. So now it's become a process within a certificate of use. So no business can have or even go through the CU process without Durham approval being obtained first. And Denny's, I believe, applied back in 2008, and by then they wouldn't have had Durham. So that's why they're requiring that Durham is literally.
And why is Durham holding it up?
I'm not sure. You would need to speak with Durham.
Okay, Mr. Lobello, is it something about the grease trap or some other aspect of the operation?
It's only the Recertification chapter, Your Honor. So they won't give us any indication. They say they're backlogged. They have so many cases that they can't get to them all, and they'll get to ours by the end of the month with comments, and then by the end of the month we'll have comments. If there are any comments that we have to correct, we then will have to do whatever they say we need to do, and then once they release their certification, then we can take that certification along with zoning, which we've already gotten, and bring it to North Miami, and then we're done, sir. But we as you'll note on the application, we did this all back in July. I've only been the owner of this establishment for approximately 5 years. I know nothing about 2008. I knew nothing about this process at all until I was told about it in June. I hired a architect, an engineer, as well as a expediter to try to expedite the process to get through this. I will tell you, Durham did certify us about a year ago to have a liquor license. I went through the same process, and it took almost a year for Durham only. But I have everything else ready. Everything else is lock, stock, and ready, Your Honor.
Okay, I want to hear from the city. Is there any other issue besides the holdup by Durham? Is there anything about the restaurant or its operation that is a threat to public safety or constitutes a violation of city code?
Not that I'm aware of.
Okay. All right, I'm gonna table this case for 30 days, actually until my next meeting in December. That's about a month and a half, and then we'll see where you are. I'm not going to enter an adjudication because I think you've done about as good a job trying to get this through as any owner. And because of the Durham issue, you can't get it's impossible for you to get a certificate of use or a business tax receipt.
Allow me to interject. So according to Raphael's notes, in January of 2019, they were notified of what needed to be provided to us in order for us to issue licenses. I would say from June at least until now, we have had restaurants apply and got Durham approval. Now, of course, every case is different, but I just wanted to throw that in there. So sometimes Durham does give the runaround, but it's incumbent upon the applicant to reach out to them on a weekly basis to make sure that their application is being put forward.
Magistrate, if I can just help clarify a little bit, what he's referring to is that the restaurant owner, I'm guessing, or someone on behalf of the restaurant must have come into the city back in 2019 to obtain the business tax receipt. And they were advised at that time what needed to happen with respect to the licensing and the Durham approval. And however, code enforcement had not issued any violations back then. What appeared to have prompted the movement was the issuance of the code enforcement violations. So I think what we're attempting to articulate here, and what I would ask you to reconsider, is the adjudication for consideration that the knowledge was not just given back in June and movement made immediately. Based on the city's records, the business owners were made aware back in 2019. Here we are, 2021, end of the year. So, we just like you to take that into consideration in your ruling.
Okay, sir, let me hear from you. It's the city is saying that you've had more than sufficient notice going back to last year that you would have to go through this process. Now, I know you were not here 5 years ago, but you were here last year. What have you done over the last year to get this approval from Durham?
2 years ago.
2 years ago.
Sir, is that addressed to me?
Yes.
Sir? Yes, sir. That was the liquor license that I applied for, and I personally applied for that liquor license, and I personally went to Durham. They signed off on our licenses. They gave me no information saying that there was any altercation, any further necessary information. They did not tell me I needed to have a business tax license. They told me nothing because they signed off on it, and I have proof of that because I have the liquor license as well as their approval. No one has ever notified me. I would sure love to see how they notified me, but I personally walked that through each and every city and I was given a liquor license and I was not stopped in any fashion whatsoever. I can show proof and send you proof of our liquor license as well as all the documentation as we walk through that was stamped through.
Yeah, but the liquor license is a separate issue from getting a business tax receipt and a certificate of use. So,
with all due respect, I understand that, but I was not aware of any certificate of use or certificate of business tax. When we applied for the liquor license, they told me I had to go to the city of Miami with zoning. I had to go to Durham, and I had to go to some other place. I forgot the third place. It was the sales tax. I had to be concurrent with my sales tax. All three of them signed off on my application so that I could go to the Broward County and apply for our liquor license.
Dade County.
Dade County, pardon me.
Special Magistrate, to answer Russ's question, Raphael is stating that he spoke to, had a conversation with the manager, Gloria. At that time, he's saying that here, I'm sorry, it's busy in his office, so he's saying he can't get away, but he's sending emails. He's saying that he spoke to Gloria and Pacifically on January 25th of 2019 and explained this in detail as to what needed to be done.
Magistrate, I just want to can you clarify, because without the city official being on the call, Raphael is our business tax receipt specialist, and he's listening to.
Am I about to give testimony with no camera?
No, you gotta be on camera in order to give testimony.
Actually, I'm going to join Isaiah on his camera. 1 moment.
Before anybody else speaks, did the business have a BTR and a certificate of use at any time? Or this is something that came up 2 years ago that they never had it?
So, Pilar, can you swear Raphael in, please? Pilar, can you swear Raphael in, please?
I couldn't see him, I'm sorry. Raphael, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Yes, Raphael, please state your name and your position.
Raphael Padron, Administrative Coordinator, Business Tax Receipt Office.
Has this business ever had a tax receipt?
The Denny's has had a tax receipt, but not under this ownership. It was a different owner back in 2015, I believe, and after 2015, there's been no tax paid on that property.
Oh, I thought it was just this year that they hadn't applied for.
No. Denny's has been since Denny's was purchased by Realty Resource, by the current group. There's been no business tax receipt applied for since 2016 that they purchased the property, or since they purchased the franchise.
And how come the city didn't do anything until now?
Well, in 2019, we did reach out to them. Business Tax Receipt Office spoke to Gloria, which was the manager, and she assured that she would relay this to the Denny's owners. And it wasn't until the city, they were finally cited that the ball was rolling.
Well, whether somebody, Mr. Lovello, whether somebody from the city told you or didn't tell you, and maybe you didn't know better, but at least in every city in Dade County, you've got to have a business tax receipt. It's elemental. I mean, if you operate a restaurant, you know that you got to have something on your wall with a, tax receipt, business tax receipt, certificate of use. Why have you never applied for one?
I don't know about other cities. I'm sorry, I don't know about North Miami, but other cities, I don't have a certificate of use permit, nor do I have a resale sales tax receipt in the restaurant. I don't know that I have a business tax receipt in other restaurants. I don't know, Your Honor. And this is, again, when he talked to Gloria Ita, Gloria is no longer with us. She left shortly after that. She had medical issues, but she never notified me or anybody in my team, or we would have taken care of it back in 2019. But sir,
when you bought the business back in 2016, did you see a business tax receipt and a certificate of use posted somewhere?
No, sir.
Okay.
They took all of the previous owner took all of their licenses. We had a heck of a time getting a health license because usually you just turn the license over, you write the new name, and you send them in, and you're done. But it took us forever to get all these things done. Realtor Resources is an out-of-state franchisee, and they were horrible. They were horrible operators, and that's why we bought them out. But I've been compliant. I've been doing my due diligence since I received this letter. I mean, RK Plaza has never even gotten the conversation in this either. That they have never been cited or even called. If I would have thought if you couldn't get from 2016 till now, if you couldn't get something, you would call the owner of the property and let them know. Let me tell you, RK Plaza is on top of me like white on rice about everything.
All right. So we have a violation. You need to go through Durham.
Yes, sir.
I'm going to reconsider what I said earlier because I did not know that you didn't have a certificate of use and a business tax receipt since 2016. And I think certainly Denny's. I mean, if you're a mom and pop operating a little sandwich shop, it can be excused that you don't know that a certificate of use is necessary. But Denny's, come on. I've been going to that Denny's for 20 years, and it's an outstanding.
I have 5 other Denny's, and none of them have them. I don't have any certificate of use in the other 5 Denny's.
All right, I'm going to agree with the city. I'm going to adjudicate you guilty, and I'm going based on the testimony that I've heard. I'm going to set a compliance date of 30 days, and in the event of non-compliance, there will be a daily fine of $500 until the violation is abated. So go talk to Durham and the city, and if you run into a problem with Durham, we want to see evidence of what the issue is, and maybe you can get RK to go with you to Durham and get the thing finished up because 5 years without a business tax receipt is not acceptable. So with that said, do what you have to do.
Sir, can we just pay the yearly fee for that tax? Again, you have never notified me. It's not written in stone that it says that this has to be done when you have a business to business. And Isaiah, if he went into the restaurant to notify the manager, why couldn't he talk to RK Plaza? Why couldn't he pick up the phone 2 years ago and notify me? I don't understand why I'm being held accountable for something that is not visible. I have 5 other Denny's, 2 others in Dade County, and neither one of them have a certificate of use. Neither one of them.
Well, because the code says you have to have it, and RK should know better. And ultimately, it's going to be RK's responsibility to comply, because if there's no compliance, the fine accrues to the owner. And the owner, in turn, is going to go after you under the lease provisions, which say that you're responsible for any licensing. So it's a circular way of getting to you, but ultimately, it's the owner's responsibility. So if the owner is still listening, which I hope he is, he has as much interest in getting this thing resolved with Durham as you do, if not more. But in any event, the city needs compliance. And so we're giving you, what did I say, 30 or 60?
30, but can I get 60 days, Your Honor? I'm asking you for 60 days.
All right, I'll make it 60 days. And I'm sure that you and the landlord and the city staff will you just have to talk to each other. You just can't blow it off and say, talk to my secretary or talk to my,
That's not my style.
Okay, well, whoever, let's work together to get this thing resolved. I think we've spent enough time on it already. It's really, something that you need to do. Okay, next case. We have another RK file that we need to look at.
That's a different location, Magistrate.
May I maybe you?
Actually, yes. Actually, is it the same RK? I think it is.
I'm not with RK Plaza. I'm with Phoenix Management.
Right, sir. The magistrate ruled in I believe your case is concluded.
Oh, you said I can leave. I'm sorry. I thought you said no. Thank you. Have a great day, everybody.
Yeah, we should have one for 2178 Northeast 123rd Street for arcade.
Yes. That item is item number 43, case number FYBRR 2020-00051. Property 2178 Northeast 123 Street, Gary Beswick is the officer.
Is this property different than the one we looked at earlier?
Yes, yes.
Okay, let me hear from Mr. Beswick.
Well, good morning, Gary Beswick, City of North Miami. Basically, it's another property for 40-year recertification. Mr. Andrew, where are we with this property?
I'm still here, guys. So we, similarly as the other property, we've engaged already engineers, structural and electrical. They've completed their inspections. I've not turned in the report. Here I've got a number of, smaller tenants, some mom and pops, as opposed to the one at 123rd in Biscayne, where we have more national tenants and kind of different level of sophistication. We had some minor stuff here, electrical panels that were blocked, uncovered outlets, some small things that the electrical guy had deemed that he wanted to get redone. I've also asked him here as well to do the illumination report. It wasn't done in his first round, but knowing from my experience at our other property, which we just discussed, that I'm going to need it. So the reports have been done. They have not been submitted yet, but I would anticipate being able to submit those to you guys, completed reports next week.
Okay.
All right, what did we do with the prior case, Mr. Beswick? We gave him some time?
Yes.
You gave me 30, Your Honor, on the last one. I would request 60 just because I'm not quite as far along on this one, and I'm still relying on engineers for
all right, so the city concurs on that. So
thank you.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation is still in effect, proper notice has been given, the owner has appeared. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
You're welcome. Have a nice day, Your Honor. Sit there.
Thanks, guys.
The next case on the agenda is going to be item number 46, Sailboat K Condo Association, case number CEEXC 2020-00008. This case was previously adjudicated with an abatement date of July the 8th of 2021. The fine set was $1,000. The property address is 13499 Biscayne Boulevard, and Shanna Sanders is the officer.
Who's here on behalf of the owner?
I have the property manager, Ezekiel, and I'm looking for the attorney. Oh, here she is, Rachel. A moment.
Good morning, Your Honor. Rachel Streitfeld, Brightside Legal, 1455 North Treasure Drive. I'm here on behalf of Sailboat K. The property manager, Zeke Shalom, is here as well.
Good morning.
Good morning.
Good morning.
We're here to provide you with an update. This is a code violation for exterior mold. And the last time we spoke to you, I believe it was 60 days ago, sir, you had given us time to move forward with repairs that are being done as part of the building's 40-year recertification. And we gave you an update on the process that the manager was going through with the association to pass the special assessment and retain a contractor. So we have taken those two significant steps. The association has approved its 40-year recertification special assessment. The owners are being billed and are paying their bill. We do have an accounting firm and a real estate transactional attorney that is also advising the association. So they are moving forward. There will be repairs made. Everything obviously will be permitted. We don't have a contract signed, but as soon as we do, I will provide that update to the city. And I believe that's all I have. I don't know if you have any questions.
Well, you heard my comments early on about the 40-year recertification issue. in the wake of the Champlain Towers catastrophe and others similarly situated. I'm losing my patience with this property, and I know that that we've made some progress, but I've frankly, I want to hear from the city first. But if you have a mold issue, fix it. Ezekiel, you're shaking your head, but I saw pictures, and no, I'm not calling on you yet. I'll let you speak in a minute.
Okay.
But I don't think you understand the urgency. Here we are. This first came up October 2020, I think, and we're still talking about just recently passing a special assessment and not even having a contract. This is not acceptable. So before I heard you, Ms. Reitfeld, and I know that you guys are acting in good faith, but maybe the directors need to, maybe we need to light a fire under their tushes, and make them do the right thing. Let's hear from the city.
Anna Sanders, City of North Miami Code Compliance Officer. As I've already stated, it's just been going on for over a year. I originally, had a conversation with Zeke about the exterior of the property, about the pressure cleaning, just bringing, into compliance, a fresh painting. It's been an enormous amount of time. We've already found it guilty, so I'm definitely okay with moving forward with eradicating the fine.
You mean ratifying the fine?
Ratifying the fine. I don't want to continue to let this drag on every few months with a update, because again, for the city, it's the entranceway of the city. It's on Biscayne Boulevard, the first and tallest building that you would see as you enter. So, I would like to be moved forward.
Magistrate, if I may, I just want to, add a little bit of perspective into this situation. I haven't spoken with the attorney in a little bit, but Steve Pizzillo, who was the building official a couple months, well, he actually just recently left. He was working with the property manager, the attorney, on the issue, the code enforcement issue. However, during doing that, I think they discovered that there was an issue referenced the 40-year. And Rachel, please, feel free to correct me if I'm wrong. I don't have the details. He's gone. We do have a new building official, and Gary, maybe I don't know, but I think that we kind of agreed to give some time on the exterior paint issue as they dealt with the more, serious issue, which I believe was the 40-year building recertification. And I think that's why we're discussing the special assessments and what have you. Although that's not the case that's before you, I just wanted to make sure I clarified that, because whereas I agree the paint issue has been ongoing, but I believe that we internally, myself and Steve Pizzillo at the time, kind of agreed that there was a little bit more of a grave situation in terms of the structure of the building itself. And I think that's where the building is in terms of, getting the special assessment so that they can deal with the structural issues. And then obviously, once that's done, take care of the exterior paint.
All right, wait, everybody relax. Because there's a new wrinkle that that has come up. Do I understand your comment, Ms. Patterson, that the prior adjudication and fine dealt with the 40-year recertification, and that we're now hearing a separate matter involving the exterior wall, the mildew, the exterior aesthetics?
No.
Are we dealing with two separate issues?
So in conversation, yes. On the docket, we're dealing with exterior paint, but the reason we decided to give more time in relationship to the exterior paint was because during the course of dealing with this issue, we discovered that there was a pending 40-year recertification that needed to be done. That's not before you, but that's why we decided to postpone or give some time on the paint issue while they dealt with taking care of the special assessments with the owners and getting the structural issues as it relates to the 40-year recertification done. And then we would later come back, and obviously once they take care of the structural issues, they would address the exterior paint. But the 40-year recert is not before you currently. What's before you is the exterior paint.
And
can I say something?
And wait, and the fine that was set along with the abatement date of July 8th, that was the 40-year recertification? Or
no, it was referenced the exterior paint, but if the clerk can clarify, the ruling at that time was very specific. You had asked for them to come back in 60 days and give you an actually they were supposed to give the building official a monthly update on where they were with the special assessments in terms of dealing with the structural issues, but the building official has since left. So because he's not here, they're here to give you an update on where they are with the special assessments in relationship to the structural issue, which I think you agree is much more serious in terms of, well, in comparison to the exterior paint. So they're going to deal with the structural issues that's not currently before you, but that's what we discussed back 60 days ago.
Okay, I understand. Nonetheless, the city, as stated by Officer Sanders, is very concerned about the appearance of the outside walls, this building occupying a very prominent intersection within the city. And I remember either the management company, the attorney, or Zeke telling us that they were going to deal with it as part of the 40-year recertification. There was a timing issue with scaffolding and shoring and what have you. Ms. Patterson, are you suggesting that I listen to them to see whether there's some equity here that wants to, that you want me to consider?
I am, magistrate. I'd like for, for you to give consideration to the structure, because I agree that the structure, I prefer that they deal with the structure. I agree that the paint, is a blight at this point, but, I think that, they're here. I think that the attorney did give an update on where they are. I don't know how detailed we need to get with that, but, if we can maybe even just get a projection on, a timeline on, when the assessments will be done and when will the work commence? Okay. I thought I heard them say last time that they could very easily pressure clean the walls if the city pleased. If that's what the city wanted them to do, they could do that. And I agree that that's not that complicated. If Rachel, I'll let the attorney. All right, I'm not defending the case. I just wanted to make sure that I clarified and gave some perspective. Yeah. But I'll let the attorney do her job. I'm just very frustrated that we've been here a year and we've seen what can happen when structural issues and other life safety issues get in the way. And we've all read, probably by now, dozens and dozens of reports and articles in the media about board members not wanting to spend any money and letting their buildings deteriorate to the point where they can cause a collapse. And that's, I don't want to read in the newspaper next week or next month that, God forbid, something happens and people die, and the media is going to come back to us, the city, the special magistrate, the building official, and say, what were you guys thinking?
Special Magistrate,
Yes,
can I say something?
yes.
Okay, give you shed light on the property. The 40-year on this building is due since 2013. And we haven't got a clear report yet. And we in 2021, so in 2 years, it's going due for the 10-year interval. So they've been dragging their feet since 2013 on the 40-year recertification.
My point. And so what they do is the board hires people, very nice people, very friendly, very competent in what they do, to come before us as the face of the association. But you're right. The impression I'm getting is that the association just doesn't want to spend the money to do the right thing, and that's.
Your Honor, if I may. Your Honor, if I may.
Go ahead.
Thank you. This is a new property manager who was hired 2 years ago to get the affairs of this condominium association in order.
I'm not blaming him.
I understand. It's also a new board. And I think that as far as equity is concerned, we have to give, on June 24th, when Champlain Towers South collapsed, I lost my childhood best friend and her 2 parents. So I take this very seriously. I'm not here just to be the face of the condominium association.
I lost 4 very good friends in that building, including my high school coach who died, unfortunately.
The sentiment is shared between us. I think it's shared between everyone on this call. There's no one who's not taking this seriously. As soon as that tower came down in Surfside, the same afternoon in North Miami, we had structural engineers on the property shoring up columns. The pool deck has been evacuated. The pool has been drained. Is that correct, Zeke?
Yes.
The pool has been drained. The pool deck is closed. There has been shoring done to the columns in the parking garage. And we have had a lawyer and an accounting firm working with Zeke and contractors to get pricing to determine the amount the special assessment needed to be. This is a situation where you have committed board members who are newly on the board, who follow up with me, who send me emails, who want to know where we are with various things. They check in. And I'm sharing this because I really sincerely want to assure you that this volunteer board, as it is currently constituted, is moving forward and is eager to move forward and recognizes the risk. So whatever we need to do with Mr. Mark Jean or Mr. Gary Beswick regarding structural or building updates, we're happy to continue to provide those. I don't know, Zeke, if we have any recent report that we could submit to the city that would let them know structurally where we stand. Do we have anything?
I have a lot of information and a lot of clarification on this. If you will allow me, Mr. Magistrate, I would love to give me just 10 minutes. I promise you I'll explain everything and you will understand a little bit clearer the issue that we have in hand and what we've done. If you will allow me.
I can't give you 10 minutes. I can give you 5. Let's see where we are.
I'll take less than that. The reason why we're here in this particular meeting is because of the exterior wall and dirty mildew stain. There is no mold. Don't use mold. Mold is a different issue. The issue here is that I came in front of you the first time I met you. I think it's been a while now. And you asked me, is there anything that you can do to better the look of the building in front of Biscayne Boulevard? And you were correct. The building, they started the 40-year certification many years ago and they stopped it because they ran out of money. That's when they brought me in to fix the issue. Now, some of the balconies still have fresh paint from the engineer painting where the balconies are going to be repaired with spray paint. These are things I can't paint. The engineering work is going to start now. So that's an issue that I mentioned before. But you told me, Zeke, if you could do me a favor, and I also talked to Sean about this, if you could paint this side of the building and paint it and make it look white and make it look clean and do it, that will be fine. And I went ahead and I complied with that. I went ahead and painted that whole side of the building, which was not finished painted, and now the building looks clean. Yes, you're right. It still has mildew and it still has some some stains and spray paint. But that spray paint is from the engineer. That's for the 40 years. So at the last meeting, I tried to explain that to you. And I said, yes, you're right. It has that. Now, if you want me to paint the whole building, And then the engineer is going to start work next month. They're going to start work right now. They're going to start work. They're going to have to go back there again and repaint it with the black paint or the red paint or the green paint and blue paint, which engineers use to show where the work is going to be done, is counterproductive. So we agreed on, okay, what I want you to do, the special assessment, I want you to have a contract. I want you to start the work and put the paperwork in. And that is exactly what we've done. We did the special assessment. Remember, it takes almost a month just to set up the special assessment. You have to send letters. You have to follow with Statute 718 of the state of Florida. We did that. We had a meeting 2 weeks ago. It was approved unanimously by everybody in the board. Apart from that, at that particular board meeting, we had 4 sealed bids. The 4 sealed bids were open at the meeting, open meeting with everybody. We had almost 80 people, which we've never had that many people in the building. And we decided on a contractor. The contractor and the engineer are working right now, are doing the plans to be able to put it in the city, to be able to start work as soon as possible. And this is being done before we even get the loan. We still have to wait for the loan, but it doesn't matter because a special assessment will start on November 1st. Whatever money comes in, I will dedicate to fix it. Now, the issue of the structure, when the Champlain Towers unfortunately fell down, we already had the engineering report from a year before. It takes a year to do this, not 5 days. We had the engineering bids, or the contractors done before that happened. Your engineer came to our property. We had, I think, the mayor came here, if I'm not mistaken. I think also the 2 of the councilmen came to the property to make sure and take a look what happened. And we showed them, we walked them around the property. We showed them all the paperwork, the engineering report. They had access directly to the engineer, and the engineer explained that the property is in good condition. There is some work that needs to be done. And even before the Champlain Towers came down, before that, I already had the water in the pool out, and we've been working on this. Now, if you insist that I fresh wash the building, that I put this, just to put up the cleaning crew to be able to do that, it's almost $10,000. I'm trying, you need to understand this is not a high-end property. Now, we just did a special assessment of $9.4 million to be able to do all the work that needs to be done apart from the 40-year concrete restoration. But in this particular stage, what we're talking about is the dirty walls and the mildew. There is no mold. Please don't use the word mold. There is no mold in this building. So I apologize if I'm a little emotional about this, but I spend 10 hours a day here trying to make this place better for the city and for you. Tell me what you want me to do. I'll do whatever I can. Okay. And the board has done an excellent job. I want you to know they're really good. They're really,
well,
want to spend all the money they have.
I commend the board, the new board, for tackling the problem, acknowledging the problem, and moving quickly to try to get it resolved. I don't necessarily feel the same way about the prior board, because where were the reserves to pay for? I don't give them as much credit as you do, because they happen to have passed a special assessment. Yeah, special assessments are necessary from time to time to do routine stuff that is, not anticipated. All of a sudden something breaks, you want to fix it. But $9 million that you had to go out and pass a special assessment. Why was there not enough money in the budget to deal with these issues that have been ongoing for years? I know it's not your problem.
I know that, but I know what happened. 80% of the people did not pay the condo fee. Now we have less than 5%. Now everybody's paying their condo fee.
Well,
but not now. But when I say now, I mean in the past 2.5, 3 years since I've been here and since the new board has been here. So we changed the building around. The building is in great condition.
I want to see how great a condition. No, wait a second, council. Just let me just get my thought out. I want to see what this wall looks like, because I saw a picture of it in the file, and I'm hearing from Zeke that maybe it's a little nicer now. Maybe they pressure cleaned it. Maybe it looks nicer now.
Yeah, it's beautiful.
I want to see what it looks like. That's all.
You should have a picture there. I'm sure that Shana has it. We should have a before picture and an after picture.
Sorry, what's the date of the final reinspection, Shem?
It's October 1st.
This is the most recent picture?
Yes. And as you're looking here, as Zeke was stating, you see the up under the balcony areas is where there's this day it was raining, I have to say, but it's gray. Seems like maybe some restuccoed work and spray paint. He's saying it's gray spray paint, but it looks kind of like restucco, from the street. And black spray paint, I guess, from his conversation as to where the construction is going to be done.
Shanna, why don't you show him the part of the building that the way it was before and the way after we agreed that I painted it and it looks really nice, which is the one on Biscayne Boulevard. This is the.
Our director is going through the photos to show what's what.
Okay.
She can show the before and after. And as he said, he did pressure clean the building, and it looks different than what it looked when it was originally sited. It does look different from what it was originally cited.
You have more pictures that I know of. This is the front of the building on 135th Street. The case on this exterior wall, the pictures that you sent us, you see right there. You see that's underneath there. That's all going to be repaired. And then
as you're showing here in different spots, there's still he pressure cleaned along the west side wall.
Yeah, there you see the balcony there. That's
What's
all
the problem
engineering
with that?
report.
What's the problem?
It's the engineer. He marked it where he wants, the contractors to come in and repair that area. It's actually not the concrete itself also. It's the electrical that goes to the air conditioning unit that has those little things. So they have to do, there you go. You see, that's all paint. You see, it's a marker for the engineer. And there's several balconies like that.
Yeah, that gray area underneath the balcony slab, that is not a...
No, that's peeling off. That's the peel off. That the paint is peeling off.
And that's what I
I
explained
think
to
he's
Zeke, all of
referring to
this
this line. Is it this black line here? Is that what we're talking about? What are you pointing out?
No, that's...
Go up some, but right up under the balcony is what I think he's saying.
There, you see several balconies there.
Yes, those areas there.
Yes.
And what are they areas where somebody scraped, or is it the balcony ready to collapse?
No, it's the electrical tubing that goes from inside the building to the air conditioning unit, and it goes through the slab. So the air conditioning electrical work is the tube is rotted out, and it needs to be cut off and replaced.
It's more
and
than
of course
just spray
the
paint.
concrete.
So
Yeah,
to
of
answer
course
your
it is.
question, Magistrate,
Yes.
it's more than just spray paint. It seems it's peeling paint. You can see some of the rebar in there.
Well,
is he
as
saying
I said,
some
it's the
piping?
electrical cables. It's the electrical cables, not rebar. But that's okay. It's similar.
But, yeah,
It still
I'm
needs
looking
to be
from the
repaired.
street, but yeah, it's more than just spray paint. It looks like stucco work. I could see some of the. I guess you were gonna, and I apologize. I'm not. I'm not a building person, but you could see. I guess it's the dry board or something up under there. It's more than just.
What about the side of the building?
Cleaning.
Show the side of the building that needed the paint that was horrible, and then we painted it and made it look beautiful.
And I give you that much. You did that area, but it's still other areas that still need to be done. I mean,
that was
my
a quarter of
concern-
the building, but that was a quarter of the building facing Biscayne Boulevard, which is what made the property look ugly. And the magistrate says, I want that to be beautiful because that's what people see. And I said, I will do that. And we went ahead and got it done. We're still paying for it.
for which I give you lots of credit. And
I understand.
I appreciate that.
We are the issue here is that the reason for the dirty and the mildew stain, you're correct, it's there. If you insist that I fix it now, it will cost more money than the money that we have to do the repairs itself. So as soon as I finish the repairs, we will do it. And we're doing all the work. We're doing all the diligent work. So you want to spray it? It's going to cost me $10,000 just to spray it. Just to get it. No, not to spray it, just to get the trapeze on there.
I'm trying to find a solution mindful of the expense and the fact that the work is going to get done. And I don't want you to waste money. On the other hand, I don't want this to be an eyesore in the city. I cut off counsel earlier. I want to give her an opportunity to respond to any issue that has come up that she would like me to consider.
Thank you, Your Honor. I appreciate that. I just want to, for the record, state that, we don't have any engineering reports submitted to the record right now. And there was a lot of speculation about what may or may not have been going on those balconies in the exterior. And so I just want to clarify that as far as the structural issues are concerned, what needs to be done, the work that needs to be done, I would be very happy to provide via follow-up, just maybe back and forth with the building official, or we can provide an update at next month's magistrate, what is happening structurally and how much time it's going to take for us to get plans submitted and for work to commence, because I want to be able to give the city a realistic time frame for when these balconies, and I understand that we are at the gateway to the city, and that it should look nice, but the reality is that there is going to be construction on this corner, on the facades of this building for the foreseeable future. And so regrettably, that's going to be what it is. And I appreciate what Your Honor is saying about trying to find the right way to mitigate the impact of the costs. And I will also say I appreciate you questioning where was the board before. But as Your Honor well knows, condo associations have the right in the state of Florida, as the law is currently written, to waive reserves. Yes. And I personally, as a legislator in North Bay Village, have been advocating for a change in that policy and looking for ways that cities can work with condominium associations like Sailboat Cay. That's a bigger policy question. We're in the situation that we are in now. They have passed a significant special assessment. They have done it in a way that is mindful of the owners and their ability to pay. And we are trying to also do the best we can for the city and show you progress while also, not bankrupting our owners, essentially. So let us report back in a month. I will get contract information and have a timeline. And I will speak personally with the engineers and ask them how quickly they can move the plans. We have a lot of work that needs to be done, Your Honor. I don't want to understate it at all. There are issues that need to be addressed through this process, and we have passed enough money to deal with all of the issues, but there are a number of agencies involved who need to approve.
All right, here's where I stand. I'm not a big fan of status reports coming to the special magistrate because number one, it's time consuming. It's often a waste of time for me and the city. I'm more of a fan of the building official and the building department talking to you and discussing the issues, finding solutions and moving things along. And then if and when it becomes a real problem where public safety is involved, life safety issues come up, then at that time, the city will decide through its building official if further steps are necessary. To the extent, as you know, in some places, not far from North Bay Village, in fact, one right next door in Miami Beach, which happens to be owned by the mayor of Surfside, Charlie Burkett, and other buildings in North Miami Beach have been evacuated because of these concerns that we're raising. So I'm not the building official. I can't red tag the building. I can't shut you down. All I can do is fine you. So at some point, you need to convince the city, the building official, that there is no life safety issue for the protection of the residents that live there. So, you know, if you have reports,
I believe that we have done that.
Yeah, we have.
There have been numerous site visits from the building officials since June 24th, and they're confirmed that there are no life safety issues at the building.
They've come here 5 times, and they spent hours on end with me. We went in the engineer. They had direct access to the engineer report, the safety plan, and they went through everything. And we promised that we would inform them every 30 days, and we have complied with them.
So give me a timeline. Maybe you're not prepared to give it to me today, but I want to see a timeline of when the contractors are going to get to a point where they're going to be able to remove some of that mildew and paint and do it in a sequential way so that you don't have to paint and then repaint. When is that going to happen?
Okay, I can go ahead. I'm sorry, Rich. Go ahead.
Are you going to answer his question with a timeline right now?
No, I'm going to tell him that I need to then confirm. Remember, we're doing this at this moment. So the engineer and the contractor are just about to start putting the paperwork inside the city. So now is when they're going to have a timeline. So as soon as they have that together, I will gladly get together with the new engineer, the city engineer or the city manager. Yeah, or with Crystal. She's been very kind with us as well. And with Shana, anytime, you know, I'm here available.
Follow up with the building official, Your Honor.
Yeah, with the building official. We'll do that. As soon as we have that, we'll do that. But you need, I see that you understand what we're doing. And I will do whatever needs to be done to please the city so the city can understand about the beauty of the building. But I am worried about, as I said, there is no reason to worry about the structure. At least that's what all the engineers and everybody that's come to the building has done. But I do want to be able to please as much as, so I can set it up that maybe we could do that area first before the other, or, you know, whatever needs to be done that's more important is what should be done. I know I'm talking.
I think that you should deal with the problem areas first.
There you go.
And as you sequence construction, then you should prioritize those areas that are causing the heartache,
yes,
and the heartburn of dealing with this on a regular basis. So I'm gonna turn this back to Crystal, and I know that staff doesn't like to give me recommendations, but I want to hear what staff has to say about having heard everything that has gone on here. What do you think should happen going forward?
So, Magistrate, what I would recommend is that we provide the time. I'll work with the attorney and the property manager and connect them with the city's new building official, Mark Jean, so that he can pick up and work with them on a monthly basis in terms of the report that that we discussed here. And, you know, based on that, I mean, I think I'll stay in contact and I'll be a part of that background process. And if that's, you know, and I guess because I don't get the impression that they're ready to give us a solid timeline today on when the building will be painted. However, it does sound like they have made the steps necessary, or are taking the steps necessary to take care of the structural issues, which will result in the building being painted. So I would state that at this point, let's go ahead and the adjudication has already been entered. We can table this for 60 days. I'll work with the attorney and the property manager and the city's new building official to ensure that the routine and regular updates are happening in order to move the project forward.
All right, that seems like a plan. Again, I don't want to keep hearing this on a regular basis. I would rather that you guys keep working together, and as long as both of you are happy that progress is being made and the public interest is being protected, fine. Bring it to me once you reach an impasse and you can't work together anymore, because it doesn't help you know, bringing these discussions up, and you know, we spent an hour going back and forth, and we end up in the same place. You know, they need more time. They need more time. And I understand construction. I used to be a construction lawyer at some point in my career, and I understand these problems, and I sympathize with what the new board has to deal with. They have to deal with issues that were swept under the rug for years by a prior board who did not want to, you know, take the bull by the horns and handle it. And you know, I didn't want to bring up the Champlain case. I believe me, I had some very good friends that died there. I have some. My wife sold many units there as a realtor, and I used to walk that property almost every single day, and it hurt me very much to see many of my friends die there, including a structural engineer who I've known since I was a kid, and he died in that collapse. I don't want to see more people injured in these condominium cases. And yes, the condominium associations do have the right to waive special assessments. The question is whether that's a breach of their fiduciary duty to address these issues. And hopefully the legislature will deal with it at the next session. But you got to have reserves in case these issues come up. And I don't want to, you know, use my job, my role to espouse these feelings, because that's not what I'm here for. But you know, let's do the right thing, guys, and let's get this done so that we don't have to deal with it. Crystal, I will table this for 60 days. I'd like to, you know, I'd like the city to see if they can move this along quicker. I'd like the association to cooperate with the city, and let's see where we are 60 days from now. And Rachel, good job in North Bay Village. I like it. I almost worked there once. I happen to be a neighbor. I live on Normandy Isle.
Oh, thank you. We're really proud.
Your police chief is a very good friend of mine who lost his mother there, by the way. So I'm very aware of you know, what went on there. Thank you, folks.
Thank you very much.
Thank you. Good luck.
Thank you.
Okay.
Thank you, Ms. Parsons. Thank you, Shauna Sanders. Thank you, Mr. Smith. Goodbye.
Bye.
Bye-bye.
Next case.
The next item is item 24, Local Union 390 BU, case number FYBRR 2020-00043. Property address is 12365 West Dixie Highway. This is a new case for Gary Beswick.
What's the number?
24.
Okay.
I have a Leonel Morales here on behalf of the property. Leonel, if you could just enable your audio and video to be sworn in.
Who's here on behalf of Local Union 390 BU? Leonel Morales? You're muted.
There you go. You hear me now?
We hear you.
Sir, could you please raise your right hand so that I can swear you in? Do you solemnly swear in affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Thank you.
Okay, sir, you're here on behalf of the property owner at 12365 West Dixie?
That's correct.
And what is your relationship to the property?
I'm the controller of the Teamsters Local Union 769.
You're the what, the president?
The controller. Controller, bookkeeper, office manager.
You broke up, sir. You'll have to repeat what you just said.
I'm the controller of the Teamsters Local Union 769.
Okay, gotcha. All right. Do you understand the nature of the violation before me?
Yes.
You do or you don't?
I do.
Okay. How old is the property?
This property is around 40 years old already.
Okay.
Actually, we received the notification of Mr. Barry Beswick. Actually, this property is divided into building 1 and building 2. We use for our facilities and office the both buildings. We received the first notice in 2020. We've been working on and off because of the COVID and trying to, comply with not the have everybody at the office during the last year. For that reason, we wasn't able to start the hiring the company for the recertification. I submitted all the documents that we are right now in the process of. We hired ARC Builders and Group. They are the recertification company that they are doing they already did the inspection. They sent us the bullets or the matters that we need to fix in order to get the building recertification. The first one was the annual fire inspection. We got that inspection last Friday. We just received the report from the fire department. I will have to go to the city to get the certificate. The second one is the roof testing. I sent everything that we have for the maintenance that we did on the roofing. Then we have to replace the rain gutters in the front of the building and some concrete damage that is on the back. I submitted the repainting contract that we already working with the painting company to paint the entire building. And with that project, we're gonna replace gutters on the front. We're gonna repair the back walls and the concrete columns that it's damaged through the because of the weather. We just need a little bit of time frame. The painting project will start in the first week of November. Actually, I don't know how long it will be. It will take for them to watch the building, fix all the repairs. But I submitted all the documents that the ongoing process for.
Okay, all right. Let me hear from Mr. Beswick.
Good morning, sir. Does your painting contractor have a permit from the city?
No, we are getting that permit during the next week.
Okay. Okay, so the bullet that you're reading, is that a report you received from the architect of our engineer company?
Correct. In order to get the recertification report.
Okay, so what you need to do with that report, you also need to submit that report to the city with the fee. So we need to know what's going on as well.
Okay, so I need to submit that report to them?
Yes. Yes.
At this point, or when they finish all the...
No, you need to first, the report the initial report you get that show the deficiency, you need to submit to the city with a fee of $707.
Let me ask you.
We have it on file to know what the deficiencies are and to know what need permits and what don't need permits, and make sure all the permits have been obtained to make the correction. When permits are issued and you receive, and if the work is final, then you're going to need a clear report from the engineer to resubmit that everything is fine. But the first step is the initial report that you receive, you need to submit that to the city.
Let me ask, because we have a building 1 and building 2 is going to be 357 per location, or just for the entire property?
If my memory serves me well, I think the one building was due before that haven't been done, but it's late, so it's not 357, it's $707.
I'm sorry, how much is it?
$707.
That's for the one that is due already.
Correct. I think they're both past due. The one that we're here for today is the one for 2020, which is past due.
Yes. The other one that I have notice here I don't think it's due already, but it's our recertification. It will include both buildings or locations, or building 1 and building 2, and just one report.
Ma'am, hold on a minute. What's the address again?
12365
West Dixie?
West Dixie Highway, North Miami 33161.
Okay, so building 1 was due last year, so that one is $707. Building 2 is due this year, and you have until December 31st, is $357.
357, right?
$357 for building number
2.
That's due this year.
Actually, I already have the 357 ready. I will write a check for the 707, and I will include the report of our ARC builders with the bullets that we need to fix or comply in order to get the report.
Okay, good. So Special Magistrate, at this point, for the one that's in front of us, we just need adjudication with an abatement date.
Okay. Mr. Morales, just so that you get a better understanding, I was while you were discussing the issue with Mr. Beswick, I was actually reading the code section that governs 40-year recertification, and this is for the benefit of everybody that's going through this process, and we seem to have a few more left in the agenda. I was also looking at the county code, which is what really triggers the ability to require a 40-year recertification inspection report. The first step is you need to get a licensed architect or engineer to do a full report on the building with special emphasis on structural issues and electrical issues. And it has to follow a certain format. You just can't write a letter. It has to be in the nature of the report. That report being filed is the first step in getting the recertification. If everything in the report is fine, if the architect and engineer say everything's perfect, you're done. You pay your fee, you're done. If the architect and engineer say that there's a structural issue that needs to be fixed, or there's an electrical panel that doesn't comply with the fire code, then you have a certain amount of time within which to fix those problems before you get your recertification. So the fact that you didn't file anything is the reason you got cited. Had you filed the report timely, you wouldn't have to be paying a $700 fee, but because you were late, you got a late fee charge. On the other building, since you're filing it timely, the fee is only $350 or $357. So that's how it works. If it's a clean report, you're done. If it shows problems, you got to fix them. And again, this is for the benefit of all of the people that are listening on their cases. This is not a big deal. You get an architect, you get an engineer, go through the building. If everything's fine, you're done. You're done. It's over. You don't have to prolong the pain for months and years. You get your paperwork file, 9 times out of 10, you're going to get your certificate back. That's it. So, sir, how much time do you need to get your paperwork done? A month?
Actually, I already have the ARC builders bullet list of the things that we need to fix, because we already hired the the architectures for the inspection. They did the inspection already, and they sent us the things that we need to fix in order to get the final report. I will submit this to Mr. Beswick. I don't think that the entire all the fixing will be done in a month, because they will start working on the outside of the building in the first week of November, with a few things that the architects gave us at the report. I can keep Mr. Beswick updated while we were doing all the company, painting company, will fixing all the stuff. The fire certificate is done already, and the electrical stuff is just the matter of gutters and the concrete on the back and the painting of the building, what is left. I think that the thing that will take a little bit more than 30 days because of the time frame that the painting company gave us to complete the project.
All right, look, they're union people working, right?
Yes.
Of course, they're going to work fine. So I'm going to give you 60 days. And if you run into a problem, you talk to Mr. Beswick, and we'll take it from there. But I think you understand better now what needs to happen. So based on the testimony of Mr. Beswick and the evidence presented, I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you.
Thank you, sir.
I have a question. What is the best way to submit a report to Mr. Beswick? Mail, email?
Mail, with mail to the building department.
Okay.
All right.
Thank you.
Thank you. Next case.
The next case on the agenda is item number 6, Bishka LLC, case number FYBRR 2020-00014. This is a new case at property 12250 Northwest 7th Avenue. Gary Beswick is the officer.
I have Dahlia Roy here on behalf of the property. Dahlia, if you could accept the invitation to enable your audio and video.
This is 13050 West Dixie.
No, it's 12250 Northwest 7th Avenue. It's item number 6 on the agenda.
Okay, number 6. Bishaka.
Yes.
Yes.
Okay. All right. Mr. Roy, is that you?
Yes. That's me.
And what's your relationship to the property?
I would be the owner of the property.
Okay. Is it a commercial building?
Yes.
How big a building is it?
It is about
square feet.
11,000.
Okay.
Magistrate, I'm going to give the gentleman the oath real quick, please.
Okay.
Sir, can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
State your name again for the record.
Monique Roy.
Okay. Again, you were telling me that you're the owner?
Correct.
Or one of the owners. How old is the building?
The building was built in 1950.
Okay. And has it been subject to a 40-year recertification before?
Well, I'm not sure, to be honest with you. My father was the owner of this property. Unfortunately, he passed away last year from COVID. So that led.
Sorry to hear that. And the building is being used for what purpose?
Well, my mom runs it now. It's a convenience store.
A convenience store?
Mm-hmm.
Okay. Do you understand what is required for you to comply with the certification?
Yes, I do.
Okay. How much time do you need?
We went out and we hired an engineer, and he did the inspection and gave us the report. So I have that ready, and also the hard copy if you guys would like me to mail it to you or someone.
Mr. Beswick, what say you?
You need to submit that hard copy with a fee of $707 to the building department.
I'm sorry, how much?
You need to submit the hard copy with a fee of $707 to the building department.
Okay. Just a quick question. Just on the paper, I saw 367 or something.
Yeah, the violation, the paperwork says 357. Mr. Beswick, explain why your figure is different.
Because it's late. So it's a $350 late fee.
If you had paid on time, it would have been 357. But since you're late, there's a late fee. Usually with the county, it's double.
Okay, I see.
It's like if you start working without a building permit, a building permit may only be $1,000, but if you don't pull a building permit, when you do have to pull a building permit, it'll be a $2,000 fee instead of a $1,000 fee. That's the way it works. Anyway, Mr. Beswick, have you had a chance to look at the property?
Yeah, I've been there for a certificate of use inspection, but you need to submit a report so I can see what the engineer or the architect stated in the report.
All right. So, Mr. Roy, if your engineer or architect says everything's fine, you're done.
Okay.
If he or she says that there's some electrical problem, then you got to fix the problem timely, or you're gonna get another fine. So I'm gonna give you 60 days, like I gave others under similar circumstances, and hopefully by then you'll be in good shape. So based on the testimony of the city's co-compliance officer, the evidence presented, I find that a violation still exists of the 40-year recertification law. Proper notice has been given, I find, for the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Thank you, sir.
Thank you.
Next case.
The next item on the agenda is item 45. The Vidria LLC, case number FYBRR 2020-00029. This is a new case with the property address of 12625 Northeast 14th Avenue. Gary Beswick is the officer.
Another 40-year recertification. Who's here on behalf of the owner?
I have a Sarah McDevitt here. I'm here. Can you hear me?
Yes.
Can you please raise your right hand so I can give you the oath? Do you solemnly swear and affirm that the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Good afternoon, Ms. McDevitt. Are you the property owner?
Yes, I am.
And you are a member of Saavedra
Yes.
LLC?
Yes, my husband and I co-own the property.
And the property is at 12625 Northeast 14th Avenue. Is it a commercial property?
Yes, it's a commercial property. It's the folio is 12625 Northeast 14th, but we actually own and operate the business out of building, I guess it's building 2, which is 12605 Northeast 14th Avenue. But it's all part of the same folio.
Okay. You understand the 40-year recertification requirement?
I do, yeah. So when we bought this property, it had already just received its initial 40-year research. That was in 2007 that it was completed. In 2017, I was notified by the city that we needed to do a new recertification. And, since I'm new to the process, I'm not somebody who's owned commercial properties in the past. I tried to get as much information as possible and went through the process then of hiring someone to do the inspection for us. We did get that inspection completed on the 2 buildings and turned it into the city with our fee in 2017. But the thing that I didn't understand at the time was that one of the flags on the property, which required additional inspection on the roof
of building one, which is the 12625 property, it needed an additional testing, and that is the part that we did not complete, and that was due to my lack of understanding of the process.
Okay, Mr. Beswick?
Well, basically, as I spoke with her, the property of two different buildings, building one and building two, and both of them was built 2 different times, but back in 2007, they did them together. So in 2017, I sat them for one of the buildings. I'm not remember which one, but in 2017, I sat them for one. And they submitted a report, but as she stated, it wasn't a clear report. In order for it to close, the report had to be clear that everything is fine. So the building, another building, one of the building was due in 2020. So I notified her. That's why we're here now. So I notified her the one that was due in 2020, and that's when she brought to my attention that she just submitted the one in 2017, which I didn't realize they was putting both of them together. But basically, I told her she needed to, the engineer that did the initial one in 2017, I made a comment about the roof and the testing of the roof. That engineer now need to do a new report to clear it to say everything is fine now. Then once that is submitted, then the file will be closed.
Okay. So, ma'am, any issues? You need time? How much time do you need?
So here's the thing. I mean, obviously, due to my lack of understanding on the process, and then what I feel was like some mixed lines of communication, that additional testing didn't happen until I was aware that it needed to happen, which was about 3 weeks ago. I got that testing underway, and we received a cleared report. But now that I went back to the original inspector, the one who did the original report, they told me yesterday that they, due to the time passing, are unwilling to clear the report from 2017. So they say that I have to go through the entire testing process again, which, you know, is frustrating, but I understand. So my question to you all is, would it be possible, since I have to pay for an entire new report, to start the process anew now and essentially submit a new report 2021 with the 10 years that I would get, that I would have had off the 2017 report timing when I actually did do and submit the report?
The answer to your question is no. The notification that you receive for 2020, you can use that one, the one that was due 2020. The building that the building that is due, okay. The building that is due for 2020. When you do it, if you do the new report that you're going to do, you can have the engineer do both buildings under that one, and the timeline can start from then. But no, it can't start in 2021.
Well, but so I'm sorry, I just want to again bring up the fact that the city in 2007 cleared the two buildings together. And 2017, I submitted a report for the two buildings together again. It's a single folio, and the property has always been treated as such. So I'm really confused as to why we keep going back to this fact that there is an arbitrary separation of the two buildings and a new report being, requested in 2020.
Because, okay, the answer to your question, and it doesn't go by the folio, it go by the building, the year that the building was built. So if you have one folio, and if you have 5 buildings on one property with one folio, and each of the building was built in a separate year, it's based on the year that building was built. That's why they label them building number 1, building 2, building 3, etc. There's the year when that specific building was built. That's the way it works.
Okay, I would appreciate, I would appreciate actually, sir, if you, the magistrate, could weigh in on this, because it's really confusing to me as to why the city would clear the two buildings together as a single property in 2007, and then without any clear written notification change the policy on this particular program.
Yeah, asking you, Special Magistrate, she asked you a question.
Well, I don't know what happened in 2017. So
2007, she said 2007.
2007, I don't know what happened in 2007, but Ms. McDevitt, I'm looking at the law in front of me, and that's really my only source of legal information. It does say that all buildings and structures need to be recertified. It doesn't say all the buildings within a folio. It says all buildings. So if they may have recertified both buildings at that time in 2007 or 17, but I think Mr. Beswick is trying to tell you that there was some deficiency in whatever report was filed because it didn't cover the roof or something. Mr. Beswick, can you clarify that?
Well, basically, when she did it in 2017, the engineer at the time, he didn't clear it because of the roof needing inspection. So now when she tried to ask him to clear it, he basically tell him he can't clear it because of the timeline of the last inspection is too far past. She needs to do a brand new report.
Right. So his report dealt with one building or two buildings?
Well, there's two buildings that the report, okay, so the additional testing was only required on one of the two buildings, and that additional testing has now been completed. But the report that was filed in 2017 was for both buildings, just as the cleared report in 2007 was for both buildings.
I'm just for clarity, when I didn't do the one for 2007, but the one I did for 2017, the notification that she received was for one building, wasn't for two. Because I go by the year that the building was built, because that's what the code is. It's all how the building is. That's where I go by. It was built 40 years after it was built and 10-year interval after that.
Okay, so there was a building that was cleared in 2017, but that report did not clear the other building.
No, the report was not clear in 2017 that was submitted.
That was for one building.
Well, she said basically the engineer did it for two.
He may have done it for two, but it was only for one building as far as the city was concerned.
All right.
Okay, so now we got to do the other building because each building has to be recertified separately. Unless they were both built at the same time. If they were both built at the same time, you could probably do one report, right?
No, if it's separate building, it still do different building.
Yeah, I understand, but if they're both built at the same time, then the inspector can do two reports, one for each building.
Yes.
Which is not what happened in 2017.
No, I notified her for one in 2017 and in 2020, I notified her for the other building.
Okay.
So that's the correct way.
So, Ms. McDevitt, you need to get a new report with either the same engineer or a different engineer or architect to cover the building in question, which remains without a recertification. And we can't go back to 2007 to see what happened there because do you know, Mr. Beswick, whether that building was recertified in 2007?
I have the recertification.
For 2007?
Yes.
All right, look, here's what I'm going to do. I'm going to table this until the December meeting so that both the city and the property owner can figure out what the history is and what was recertified and what was not recertified. And hopefully the two of you can come to an understanding of what needs to happen so that there won't be a need for me to have a hearing in December. But if you need to have another certification on the building in question, then I would hope that you retain the necessary party to do a new inspection. And that way, we're done. If you agree that you need to have a recertification on one building and not the two buildings, then do it.
Special magistrate, just to be clear, regardless of when she want to do it, she still needs, both buildings still need to be recertified.
100%. But I raised the question that perhaps in 2007, she's showing me a piece of paper saying that the building that you're citing her for was previously recertified. I don't know that, but I'd like to.
Yeah, but that's not, but even though I understand about 2007, but she was notified in 2017. That report is not clear. So in order for that to be clear, she still needed, as the engineer told her, he cannot give her a clear report. She needed a new one.
All right, Miss McDevitt does not necessarily agree or disagree. I think she has questions and issues. And before I enter any kind of an adjudication, I want to make sure that she understands that we're not being arbitrary and capricious, that we're not just singling her out and asking her to recertify something that has already been certified. So, I don't know enough right now to tell who's right and who's wrong. I assume Mr. Beswick is correct, but I want to eliminate any doubt. Ms. McDevitt, I want you to understand what your obligations are as a property owner. And so what I'm asking is that the two of you have a meeting and you can discuss whether you're in compliance or not in compliance. If you're not in compliance, next meeting, I'm going to start fining you if you're not in compliance. Okay, you may speak.
Yeah, I just want to say, in 2017, when I got the recertification for the two buildings, it was right after we had done extensive and permitted work to one of the two buildings. And the thing that I want to ask is that particular building, if I understand correctly, is the one that he had. It becomes very confusing for me because when I've walked in there, there's been times where they tell me, yes, the two buildings are together. And then there's been times I've said that the two buildings are separated. But I just, again, when I've asked for things in writing or information in writing to clearly tell me this is what's happening and this is why, I feel like that's not given. Even in this particular report that I received after I submitted my recertification in 2017, it says, please submit your final inspection report to our office as soon as possible. And that was, it was just vague. And for me, as somebody who hasn't gone through this process before, I feel a little bit like I need more support from the building department to be clear on what they want from me, because I really do want to comply. In every area of my business, I work really hard on making sure that I'm in compliance and that we do things the proper way. But I do feel frustrated in this particular situation because if the two buildings were recertified together at one point, why would they be split in the future and at kind of arbitrary dates?
All right. I think you've made a very good point. You're confused, and we want to unconfuse you by telling you exactly what the law requires you to do. And if you were under the misunderstanding that both buildings were part of the same parcel and therefore subject to the same inspection, that's not true. Every building has to be recertified separately. And just because the engineer or the architect gave you a report on both buildings doesn't mean that both buildings were recertified.
Okay.
So they have to be done separately. And Mr. Beswick will explain it to you, and hopefully we can get you to a point where you understand what the law requires you to do, and there won't be a need for another hearing on this. Hopefully by December, which is the next meeting that I have, hopefully by then you will understand and you will be responsive and do whatever needs to be done. If you don't, at that meeting, I'm going to fine you for not doing the right thing. So I'm gonna table this until December.
Can I ask a question?
What? Yeah, quickly.
Would it be fair to ask the building department to provide to me in writing the information I need for, like, for which building they want me to do the research? And also, would it be fair to ask, on the 2017 report, both buildings were covered, and only one of the two buildings needed any sort of attention. But if the building that needed attention was the one that he now is telling me didn't need to be done in that report.
All right, I think we've covered that. I don't want to rehash it. The building official, the building department will have a conversation with you, provide you whatever information you need. You'll give them whatever you have so that they can review and they can understand your point of view, and then they will respond to you back and tell you what you need to do. I can't order them to do anything, but I can tell you that if their interpretation of the code is that you need another inspection, I have to abide by their interpretation of the code, because that's why they're there, to enforce the code. And I don't have the authority to go over their head and interpret the law differently than the way that it's in the code. So they will tell you what the law says, and then if you comply, great. If you didn't comply, you have to comply.
Perfect.
So with that, let's move on.
Thank you.
Next case on the agenda is item 49 for Space Galore, FYBRR 2020-00059, property 1400 Northeast 125 Street. This is a new case for Gary Beswick.
I have Carol Joy Biggs Owens here on behalf of this property. Carol, if you would enable your audio and video to be sworn in.
Hello?
All right, anybody there for the property owner?
Yes. I don't see my video though.
It looks like it's on, but I'm showing a black screen. Maybe you have your camera.
Hello, Michael. The time is 12:30 p.m. Right.
It says I'm showing video for some reason.
What's your name? What's your name, sir?
My name is Michael Owens for Space Galore.
I don't see a video, and I need to have you on in order to proceed.
One moment. Let me see if I can start the video again.
Your video is on. It looks like maybe your camera is facing the wrong direction. It's showing a black screen.
I apologize. I cannot really account for this. It is built into this desktop computer and the light is on. It usually indicates that the camera is on and working, but obviously I have no video. I have no video in front of me, as you have no
Can you
video.
try maybe dialing in from your cell phone, and we can give you some time. We'll move to another case. Maybe you can try your cell phone.
Sure.
All right, thank you. Clark, call the next case, please. We'll come back to that one, Magistrate.
Okay.
The next case is item 53, Villa Bianca LLC. Case number FYBRR 2020-00094. This is a new case for 13251 Memorial Highway. Gary Beswick is the officer.
I have a Leo Battistini here on behalf of the property. Sir, if you can enable your audio and video to be administered the oath. Leo.
We're missing Leo.
I just saw him here and I don't see him anymore, so. All right. Next case, Pilar.
The next case is item number 20, Jean Montesir and wife Marie, case number FYBRR 2020-00010, property 13420 Northwest 7th Avenue. Gary Beswick is the officer. This is a new case.
Lee Mondesir, I promoted you as well. Can you access audio and video, please?
Here's Leo.
This is Leo. Okay, so, all right, so what do you want to do, magistrate?
Let's go back to Leo now that we've got him on the video.
Okay. So that was item number 53 on the agenda.
All right, let's have the witness sworn.
Sir, can you please raise your right hand? If you solemnly swear and affirm the testimony you're about to give in today's proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God. Please say I do.
I do.
Thank you.
Madam Clerk, this is case 53.
Yes, sir.
Villa Bianca. Sir, restate your name for the record, please.
Leo Battistini.
Okay, there you are. And what's your relationship to the property?
Owner.
Do you understand the requirement regarding the 40-year building recertification?
Yes, we have the report.
You have the report already?
Yes, I sent it by email yesterday, but it needs to be submitted as a hard copy to apply.
Is the report from a licensed architect or engineer?
Yes, it's an allied inspector.
How large is your property?
19 units.
19 unit, what, residential?
Yes.
How old is the property?
It's built in 1970, and it's 13,000 square feet.
Has it been certified previously?
Yes. Not by us, by the previous one.
No, was there a prior 20-year recertification on the property?
Yes. We're doing, I guess this is the 10-year recertification.
Is that right, Mr. Beswick? This is the 10-year?
Yes.
So they have a 20-year, I mean a 40-year.
I'd assume so, but this interval is for a 10-year interval.
Okay. All right, this is the first time that we've actually considered a 10-year recertification. And just for those who are listening and those that have this issue, the county requires, and the city as well, that you do a 40-year recertification first, and then you do another recertification every 10 years thereafter. So this property owner is here on the 10-year recertification. After the 40, here's the next 10. So, sir, the report was submitted. Did it find any defects or deficiencies with the property, things that need to get done?
We had to do more lights in the parking lot. We had to do, we had to seal some of the railings of the stairs. I think there was a couple exit lights that needed to be done. Some wiring on the AC units on the roof. We complied. They inspected the building, and we have the report. I tried to submit it yesterday. I submitted yesterday an email, PDF version. However, the hard copy needs to be submitted to comply. So.
All right. So let me hear from the city.
Yeah, basically, as he stated, he sent an email, but it doesn't, you have to bring in an hard copy with the required fee, which is $707. And basically, that's when I can look at it to see what the engineer or architect stated in the report.
How late was the report?
Oh, it's overdue. It's due from last year.
Okay. They were notified back in June of last year that they were late.
That it was due then. So basically, normally the first notice go out in June of each year. Give them 90 days. Then if they don't submit anything in 90 days, then I send another notice. But technically, they have until December 31st of each year to comply. So once they pass December 31st, that's when the late fee goes in effect.
Okay. All right. Are you asking for an adjudication?
Yes.
Okay. Sir, you still have to submit the report, and there's going to be a late fee associated with it because it's been delayed. It was due last December, and I can't waive the late fee. That's something that is by law you're required to pay. Since you've already received the report and you try to send it by email, it shouldn't take you a long time to send the city or bring to the city a hard copy. So I'm going to give you a few days to do that. If you do it, I will not fine you, but you still have to pay the late fee. So based on the testimony of the city's code compliance officer and the evidence presented reflecting that the cited violation still exists, proper notice has been given. I find it in favor of the city, enter an adjudication and set a compliance date of 10 days. In the event of non-compliance, there will be a daily fine of $250 until the violation is abated. Sir, you have a question?
Yeah, the fee was $357 until yesterday. I did go in person to the city, try to pay it, but they wouldn't let me because I didn't have a hard copy.
Sir, the fee, the $357 was up to December 31st of last year.
Oh,
okay. You're 6 months, you're almost a year late. So because you're late, the county and the city require you to pay double the amount of the fee, and that's why they wouldn't take your check, and that's why you're going to have to bring the report along with a check for the right amount. So I've given you 10 days. I think that should be sufficient for you to resolve your issue. Have a good rest of the day. Next case.
We're going to move back to item number 49, Space Galore LLC. Case number FYBRR 2020-00059, property 1400 Northeast 125 Street. Gary Beswick is the officer.
And that's Carol Joy Biggs, correct?
Yes.
Carol or Mr. Owens, if you would enable your video, have you here twice. Okay. We need audio as well.
Sir, can you please raise your right hand so I can give you the oath? Do you solemnly swear and affirm that the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
All right. What's your relationship to the property?
I manage the property. Space Galore LLC owns the property. It's owned by my parents.
Okay. Have you had the property inspected?
Yes, we have. We actually performed the inspection late earlier this year. There were many items that we needed to get repaired through it. Once we submitted it, we've been working on that since. Exterior wall cracks have been repaired. Roof leaks were repaired. That was actually repaired under permit. We had a damaged scupper and downspout was also repaired. Our electrical panels were not labeled, so we had an electrician come in to identify the circuits and label them. We installed new exit and emergency lights. Many of those were bad. The parking lot illumination was not up to code, so we installed new lighting. And at this point, the only thing we are lacking is to paint the exterior of the building, which we contract signed just a few days ago. We expect them to commence in about 2 weeks. So I expect we should be able to get this completed maybe in 30 days. I'd be a little more comfortable with 60 just to make sure that we can get the engineer to come out. But that's where we stand right now.
All right, before I call on the city, I looked at your structural engineer's report. I think his name is Ricardo Neira. Is that correct?
Yes.
And he stated under oath back in earlier this year, I believe January, that the building was not structurally safe. Has that been corrected?
Yes, sir. Your Honor, it was due to the issues that I just outlined. If you look in the, I'm assuming that you have the same report that I do.
Okay. Let me hear from Mr. Beswick.
Basically, we're seeking adjudication, basically, and we can give him the 60 days that he asked for.
Okay, well, I'll do that. Based on the testimony of the city's code compliance, the evidence presented, I find that the violations still exist, that proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $300 until the violation is abated.
Thank you.
Thank you.
Next item is item number 20, Jean Mondesir. Case number FYBRR 2020-00010, property address 13420 Northwest 7th Avenue. Gary Beswick is the officer.
Good afternoon, everyone. So on behalf of the owner, Lee Mondesir.
Yes.
Sir, can you please raise your right hand so that I can swear you in? Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
You own the property, sir, with your wife, Marie?
That is my parents. Those are my parents.
Okay. And the property is at 13420 Northwest 7th Avenue. What kind of property is it?
Commercial property. Restaurant.
Square footage?
About 4,000 square footage.
And it's sole use as a restaurant?
That's correct.
How much time do you need to recertify the building?
30 days.
Okay. Is that agreeable, Mr. Beswick?
Yes. Mm-hmm.
Okay. So based on the undisputed testimony of the city's code compliance officer, the photographs and the evidence that I've reviewed depicting that the violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Thank you, sir. Good luck.
Thank you. Have a good one.
The next case on the agenda is item 55, will no parole. Case number FYBRR 2019-00009. This is a new case for 12173 Northwest 7th Avenue, and Gary Beswick is the officer.
I have a Rachel. Yes, I have a Rachel Perrott, I think, here on behalf of the property.
There we go.
Rochelle Perot.
I apologize.
Okay.
Please raise your right hand so that I can swear you in. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Good afternoon. Are you the property owner?
My father is the property owner, but I am on the deed.
Okay, and your father is Wilner?
Wilner Perot, yes.
Okay. The property is at 12173 Northwest 7th Avenue, correct?
That is correct.
Do you understand the nature of the violation?
Yes.
What kind of property is this?
It's a commercial property.
What's the size? What's the square footage?
I want to say about 3,000. It's 2 spaces, but I want to say it's about 3,000 square feet, a little over.
Okay. What kind of spaces? What business is conducted?
My father runs a driving school in one of them, and I have a real estate brokerage that's in construction, which is why we haven't been able to do the recertification.
You have permits to do construction on the second space?
Yes, we do. We have open permits right now. I have spoken to Gary before.
Yeah, I'm going to let Mr. Beswick weigh in on that.
Okay.
Good afternoon, Gary Beswick. Yeah, there's permits, but the problem is this file is from 2019. So we need adjudication and with abatement date. And by the way, what's the progress with the construction?
So as you know from before, there was like a lot of holdup because we were switching contractors because the contractors were not fulfilling what they needed to do. So finally, we have some contractors that are on now that are doing what they need to do. We just got through electrical, and we're moving along pretty good right now. So I think that maybe in a couple months, I'd say even less than that, but just because of what we've been going through, I just like to have a little time so we could get it done.
All right, you got it. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented, reflecting that the violation still exists, proper notice has been given, the owner's representative and owner appeared. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you.
Next.
Next case on the agenda is item 54, Waterstone Capital Holdings LLC, case RCCOR 2020-00014. This is a new case for 12599 Northeast 2nd Avenue. Gary Beswick is the officer.
I have a Giancarlo here on behalf of this property.
Can you first swear in Mr. Is it Moscoso?
Yes, as soon as he enables as soon as she enables her audio. We need your audio.
Good afternoon, everyone.
Hi. Can you please raise your right hand for me if you're going to testify today? Do you solemnly swear or affirm that the testimony you're about to give in each proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
State your full names for the record once again.
My name is Giancarlo Moscoso. I'm a property owner.
Can you hear me?
Your name?
Gina Vargas, property owner as well.
Okay, and according to the file, the owner is Waterstone Capital Holdings LLC. What's your association with that company?
What was the company?
Madam Clerk, is this case number 54?
Yes, it's 54 Waterstone Capital Holdings.
Yeah.
12599 Northeast 2nd Avenue.
Oh no, I think we are not for that address. We are at 13560 Northwest.
Okay, wrong people. Who's here?
So what address are you here on behalf of?
We're on behalf of 13560 Northwest 2nd Avenue.
Just a second, magistrate, please. These are these individuals didn't pre-register, they signed in. So we're trying to figure out what cases they're here on behalf of.
So you're here for Gina A. Vargas, item 16? Is that your case, sir?
Yes, my case is RCCOR-2019-0041.
Okay, so that's item number 16. Gina Vargas and Juliet, case number RCCOR 2019-00041. This was previously adjudicated with an abatement date of February the 4th with a fine set of $250 for property 13560 Northwest 2nd Avenue for Gary Beswick.
Correct.
All right. So I'm looking at Giancarlo Moscoso. Are you an owner of the property at 13560 Northwest 2nd Avenue?
Yes, I am as well.
Who is Gina Vargas, Julieta Di Manet? Who are they?
Gina Vargas
Gina
is
Vargas.
my wife. She's here. And
Okay.
Julieta de Manet, she's my mother. She was co-signer on the purchase.
Okay. So you were adjudicated guilty. A fine was scheduled set for $250 on February 4th. You need a reoccupancy certificate, and I want to hear from the code officer. Why are we here?
We're here because they were supposed to get required permits to legalize everything that it was done. Then after that is completed, then they have to apply for a reinspection for the reoccupancy certificate. So they can't get their approved REAC until they completed all the permitting part.
That's correct. That's correct, Your Majesty. And we are in the process of getting that done. There was a delay. I completed majority of the inspections. According to our last meeting, I was in compliance as well because I was doing the due diligence to complete the permits, the permitting process. There was only one delay for the plumbing, for which I was required, on top of the things I did at my house, I was required to actually do get a letter from an engineer to provide an explanation of a lot of things that were done after the fact on the house, because the house had renovations done that were done apparently without permits before I purchased the house. So I mean those were completely aside from us, and so I'm trying to get everything on legalized and everything on the permits. Like I said, the only permits I'm missing right now are the only completion of the permits, so I can actually submit my request for the certificate of occupancy. Is for the plumbing part, and I think it's just the plumbing part. I have the permit.
Mr. Beswick, I'm inclined to table this.
Yes.
Yeah, I'm inclined. Since we're moving along, Yeah, let's table it until my next meeting.
Good for me.
Okay, thank you.
Okay, thank you very much.
Thank you.
Have a good day. Thanks.
The next item is 54 Waterstone Capital Holdings LLC, case number RCCOR 2020-00014, property 12599 Northeast 2nd Avenue. Gary Beswick is the officer. This is a new case.
I have Richard Wasserstein here on behalf of this property.
I'm going to have to recuse myself on this one. Mr. Wasserstein is a relative of mine and my wife's, and so I'm not going to hear this case. It'll have to be reassigned to another magistrate.
Okay, so I guess clerk will table the item for the next hearing.
Okay.
Yeah, I need to recuse myself.
Okay, that's fine.
The next case on the agenda is item 13, Coronado Towers Condo, case number FYBRR 2019-00085. This was previously adjudicated with an abatement date of May 13th of 2021. The fine set was $250. The property address is 12590 Northeast 16th Avenue. The officer is Gary Beswick.
All right, just a second here. Carlos Martin. Mr. Martin, is there anyone else here with you on behalf of this item?
No, just myself.
Okay. Okay, this is the attorney on this item, on magistrate.
What's the item again?
Item number 13. We're waiting on you, magistrate.
Oh, I'm waiting on the owner.
The attorney is here on behalf of the property owner.
I see. Carlos Martin. Okay, very well. Mr. Martin, you represent the owners of that's a condo association, correct?
That's correct, Your Honor.
You've been retained, and I note that this was previously adjudicated back in May. A fine was set, and there was a finding that the 40-year recertification law was not complied with. What do you say to that?
I agree. At the time that we asked for the extension, we had not complied. I believe on April 20th of 2020, a 40-year report was filed with the city.
Okay, and so let me ask the city then, if it was filed, was it deemed to be in compliance when it was filed, or
no?
Was there some work that needed to be done?
Work was required. Yes.
Okay, and has that work been done?
Some work has been done. Do you want to? Would you like the inspector to speak first, or would you like me to?
Yeah, I'd like to hear from the inspector and see what the city's position is.
Okay. As he stated, the report was submitted, and it shows some efficiency. And they asked for extension. I grant them the extension. And basically, after the incident in Surfside, when we started to inspect all the buildings in the city, when we actually got there, then we realized that there were some issues of concern, and the building official at the time, Stephen Pizzillo, deemed the balconies on the building to be unsafe. So basically, it's more of urgency for them to do all the necessary repair on the building. And I met a gentleman on the property. He stated he was like a property manager for the condos at the time. And they basically was one of a meeting for a special assessment, but the balconies and the building was deemed to be unsafe, not supposed to be using the balcony in the building. So that's why I brought it back, because we need to, there's some urgency in this building.
All right, was any progress made since I heard the case earlier this year?
I'm not sure. He just stated that yes, but I haven't received a report of what they have done.
All right, show me the pictures to refresh my recollection as to how serious an issue.
I don't think I've any pictures. Normally for 40 years, we don't provide pictures for 40 years. So basically, it's just a report from engineer.
All right, and can you specify for me what life safety issues were identified in the report?
What's the case number, Pilar?
FYBRR 2019-00085.
Is the report in the case, Gary?
Yes, it should be.
Okay, I can pull up the case.
Well, I'm account to the engineer, basically, they basically mean structural repair.
Gary?
Okay. Sorry. Mr. Magistrate?
Yeah, why don't you summarize for me what the main issues were?
The main issues basically, the engineers said basically that I need structural repairs, but after our visit on the property, then we realized to the extent of what kind of structural issues. As I stated, all the balconies was deemed to be unsafe. So basically, they're going to need to do some concrete restoration to make those balconies safe.
What about interior work?
Well, there was nothing really deemed up the interior. It was mostly on the exterior for the structural aspect of the building.
Okay. All right. Let me just pause for 1 minute. I got to attend to a personal matter. I'll be right back. Just let's hold on for 1 minute.
Recording stopped.
Okay, everyone, I'm back.
Recording in progress.
Mr. Martin, we have an issue with the balcony, which is of concern to the city and to the building official. So what's being done about it?
Well, when we were first notified of the balcony, of the extent to which the city was concerned with the balconies, the first thing we did was we hired a contractor and notified the owners and prevented access to the balconies until final work can be completed. Obviously, it's going to take a little bit more time to do that. Separately, the association has noticed a 14-day notice for a special assessment for structural repairs. This is going to require approximately between the work that's required for that and there's other repairs that are necessary, about $500,000 to $750,000 worth of assessment to the association. At the same time, we've stopped the financing because the association has already been through a round of special assessments 2 years ago. It's a blue-collar building. And we've already done work on the boiler, replaced an elevator, replaced the electrical panels, roof repairs, AC for the elevator room, the garbage system, the fire system. There's been a lot of work. We've been performing a lot of work, but obviously we know there's more work done. So we need a little bit of time as we attempt to obtain financing to extend payment period and also to collect a $500,000 special assessment to 750 is quite large for a community of this size. After they've already been through a couple rounds. So if we made it due within 30 days of passage, the likelihood is something like 50 to 70% of our owners would not be able to pay it. So we're going to have to, that's why financing seems to be the best option to be able to get the money up front and make these repairs as fast as we possibly can. But we are, regardless of that, moving forward with a special assessment to adopt the assessment to allow those owners that have the ability to make the payments up front and sort of float the association to enter into the contract with the structural concrete company to begin that work to at the very least shore up the worst of it. Additionally, we've had to change engineers from our 40-year specialist as our 40-year specialist is retired, unfortunately, so we had to change to a new engineer for specification. But we are in that process.
All right.
Yes, sir.
Yeah, go ahead, Mr. Beswick.
The balconies are closed off from the, okay.
That's what I was informed by the manager, but Mr. Beswick, I will, if you would like, we can speak later on. I'll 100% confirm it. With management companies, I always want to confirm just to be 100% safe.
I understand.
Yeah.
My concern is that there was an order that I issued that required abatement by May 13th with a fine set at $250. And we're 6 months already past that deadline, and all I'm hearing is we're going to pass a special assessment. Well, why didn't you pass a special assessment last year or in May? Why are we talking about special assessments now? That's what really gets to me with these condominium associations. They think that, it doesn't matter. They just don't get it. What is going on? Why now they're talking about a special assessment? Why didn't they start this conversation months ago?
They did, Your Honor. It's not a question of a lack of desire in an attempt to do the work. They have passed special assessments. This is not the only issue. The gravity of the issue became more apparent when the city came out and advised us that it was. We were not told when the 40-year report was issued that it was an unsafe issue at the time. This was told to us within the last, I believe, 60 days from the city. There were other parts of the 40-year report that we had been completing based upon the special assessments that we had. Like I explained, the AC for the elevator room, the elevator was replaced. The electrical panels were replaced. Roofing work has been performed. Fire panel was replaced. There's been quite a bit of work done in the community. It's not that they just sat around since the report was issued and did nothing. They're dealing with a limited amount of resources in the community that is hit hard, not just by the economy last year, but also COVID. It's not a rich building. They are attempting to work with what they have. It's very difficult for them to obtain financing because, as well, when they passed that first special assessment to collect monies for these repairs, several owners went into default, and we've been in the process of collections and foreclosure. But banks will not generally lend to any community that has more than 10% in bad debt. So it puts us in a circle of difficulty in obtaining the sufficient funds necessary to make additional repairs. Once we were advised of the severity of the balcony issue, which was not, it was within the last 60 days, we took the appropriate steps to shore that up. And despite the fact that the likelihood is we're going to push quite a number of more owners in a very small condominium, I know it's 6 stories, but it's not large, into likely foreclosure. Obviously, that's going to have to be necessary to move forward, but there are very few options through the association of this type and size and demographic. We're trying to do what best we can, and we will continue to endeavor work with the city to make sure that the building is safe and make the repairs as we can.
Mr. Beswick, are you satisfied with the remedial measures to protect the public and the residents from the balcony structural issues?
Can you repeat the question?
Yeah, they say, the property owner says that they only recently found out about the structural issues regarding the balconies, and that they have prevented access to the balconies, mindful that they're dangerous. And my question is that sufficient? Do they need shoring? Do they need to evacuate? What is the city's response to the balcony concern?
Well, our response was basically for no one to have any access to any of the balcony. That was our response. No access to the balcony until all the repairs have been done.
Okay, and so have all the residents been advised that they are not supposed to use the balconies for any purpose?
Well, the last time I went to the property, I saw a sign, plus we post a sign on the property as well, deeming the balconies unsafe.
And in your opinion, the rest of the building is safe?
Well, in my opinion, basically the concern is basically the balconies.
So what's your recommendation?
Well, basically, they need to give the building department a progress report of what's going on and where they're at, because it cannot stay like that indefinitely. So the repairs, they have to address the repairs. So we need a progress report of where they're at and the contractor that they're going to hire and where they're at with the process of applying for the permits, because they're going to need permits to repair. So we want to we basically want to put them on notice, want them to give us a progress report, because first we got to give them the benefit of the doubt, let them get the progress report, because I don't want to say start the fine and basically add more debt to what they already have to spend. And I guess I can agree that the elevator was upgraded, because I'm familiar with the property. So the elevator was upgraded. So, but basically, as long as there's no access to the for the balcony, what I will do, I will have the new building official go by the property and give his assessment. The acting building official is actually a structural engineer, so I'll let him go by and give his input.
All right, here's what we're going to do, Mr. Martin. I have another hearing scheduled in December 16th. And Mr. Beswick, I'd like to meet the new building official at that meeting.
Okay.
And I would like the new building official to advise me whether or not the building is safe, the structural components of the building are safe. And I don't, if there's a foreclosure, if, it has to be vacated, so be it.
I understand.
You make your own bed. And if you were not setting aside monies, and if you were not taking care of this building properly, for years and years and years, there are consequences. And when we issue orders here, there are consequences. It's not the city's fault if the property owners can't get a loan. It's not the city's fault if the property owners the condo association did not set up enough reserves. So, I have very little sympathy for board members that keep delaying, and then now they a lot of them will face consequences also. So, Mr. Martin, you seem like you know what's going on. You seem to have the ear of the association, and you can explain to them that this magistrate will not tolerate any more delays. Come December, if we don't have a very specific plan to take care of these issues, and if the building official tells me that it's a life safety issue, we may end up ordering an evacuation. And I don't think that's in the building residents' best interest. So December is about as far as I'm going to let this go without being addressed. And we'll see you then.
Thank you, Ron.
Okay.
Special Magistrate, can we take a quick 5 minutes?
Absolutely. Let's make it a 10-minute recess. Okay. We'll see you in 10 minutes. It's about 1:15, 1:25.
Thank you.
Recording stopped.